The prayer this morning will be offered by the good delegate from Howard County.
Good morning. St. Patrick's Day is a time to celebrate the Irish American history and heritage. It's estimated that 25% of Americans have at least one Irish ancestor. I share with you today a prayer by Irish poet John O'Donoghue, who is also very appropriate for a crossover weekend. It's called For Work. May the light of your soul bless your work with love and warmth of heart. May you see in what you do the beauty of your soul. May the sacredness of your work bring light and renewal to those who work with you and to those who see and receive your work. May your work never exhaust you. May it release well springs of refreshment, inspiration, and excitement. May you never become lost in bland absences. May the day never burden. May the dawn find hope in your heart, approaching your new day with dreams, possibilities, and promises. May evening find you gracious and fulfilled. May you go into the night blessed, sheltered, and protected. May your soul calm, console, and renew you. Amen.
Amen. Quorum call.
Madam Speaker.
Morning. Clerk will take the roll. There being 118 members present, the House is still in session. Clerk will read the journal from the previous day.
Annapolis, Maryland, March the 9th, 2023.
Recognizing Deputy Majority Leader.
Thank you, Madam Speaker. Move so much be considered the reading of the journal.
So ordered. Petitions, memorials, and other papers. House resolution. Clerk will read the resolution in full.
Be it hereby known to all that the House of Delegates of Maryland offers its sincerest congratulations to the Catholic Charities of Baltimore in recognition of your 100th anniversary of your mission of care and service to Marylanders. The entire membership extends best wishes on this memorable occasion and directs this resolution to be presented on the 17th day of March 2023.
Give me. Report of the Committee on Health and Government Operations, report number 10. Clerk will read the first bill.
House Bill 48, Maryland Medical Assistance Program, Collaborative Care, Model Services, Implementation and Reimbursement Expansion. Favorable.
The question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. The favorable report is adopted. Are there any amendments to the bill as to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read the next bill.
House Bill 472, Transit Commuter Bus Service, Procurement. Favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered for third reading. Clerk will read the next bill.
House Bill 543, State Procurement, Small Procurement Definition, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Report of the Committee on Health and Government Operations. Report number 11. Clerk will read the first bill.
House Bill 261, Public Projects, Global Warming, Potential of Materials by Clean Maryland Act. Favorable amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. Move so much be considered the reading of the amendments.
So ordered.
Amendment 1 is technical, alters the short title and adds co-sponsors. Amendment number 2 establishes that an eligible project under the bill includes a capital project under the State High Performance Green Building Program. Delays by 1 year, the date by which the bill requirements go into effect, requires producers of eligible materials to submit environmental product declarations to DGS on or before December 31st, 2024, and requires DGS to analyze those declarations and assess global warming potential for eligible materials used in an eligible project, and establishes an environmental product declaration assistance fund for 1 year and 6 months to award grants to producers of eligible materials to support the development, standardization, and transparency of environmental project declarations for construction materials and products. And I move the amendments.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed? The ayes have it. The amendments have been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read next bill.
House Bill 676, Cemeteries, Pet Remains, Duty of Perpetual Care. Favorable amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. So be considered reading the amendments.
So ordered.
First Amendment is technical and adds co-sponsors. Second Amendment requires the Director of the Office of Cemetery Oversight to adopt regulations to enforce the requirement of the bill. Move the amendments.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed? The ayes have it. The amendments have been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read next bill.
House Bill 778, Montgomery County, Maryland, National Parks and Planning Commission, Consumer Requirements and Open Meetings, Montgomery County Planning, Trust, and Transparency Act of 2023.
Recognizing floor leader.
Thank you, Madam Speaker. Good morning. Move so much we consider the reading of the amendments.
So ordered.
Amendment number 1 is technical and alters the short title. Amendment 2 does quite a few things. Adds provisions authorizing a commissioner of a bi-county agency to submit financial statements to the council electronically. Strikes multiple provisions altering the selection process for appointments to the commission, relating to removal of commissioner, regarding establishing a new process for selecting a chair and vice chair of the commission, and relating to the salary of the commission. It prohibits the employment of the chair and any other full-time employment while serving as chair, alters language relating to political activity by a commissioner, alters criteria for training, strikes provision relating to agendas and minutes of the planning board, requires the planning board to report to the county delegation, and ultimately strikes the designation as an emergency bill and establishes a standard effective date of October 1st. Move the amendments.
Question for the House is the adoption of the amendment. All in favor signify by saying aye. Opposed? The ayes have it. The amendments have been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read next bill.
House Bill 783, Washington Suburban Sanitary Commission Minority Business Enterprise Utilization Program, revisions and extension. Favorable amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. Move so much be considered the reading of the amendments.
So ordered.
Amendment number 1 makes technical corrections, removes language that would have required each prime contractor to provide prompt notification to the Commission before the termination of a contract with an MBE only when feasible, retains an existing reporting requirement, retains an existing price preferences for MBEs, retains existing language relating to a sheltered market program, retains existing language on geographic considerations in the MBE program, and retains existing language requiring a study by the Commission. Move the amendments.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed? The ayes have it. The amendments have been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read the next bill.
House Bill 812, Health, Reproductive Health Services, Protected Information and Insurance Requirements. Favorable amendments. Amendment number 1.
Recognizing the floor leader.
Move so much be considered the reading amendments.
So ordered.
There are 9 amendments to the bill. Amendment number 1 is technical and adds co-sponsors. Amendment 2 authorizes a custodian to allow inspection of part of a public record that contains certain information related to an ambulatory surgical facility and allows inspection of home addresses for licenses other than health occupations licensees. Amendment number 3 alters the definition of legally protected health care and deletes from the bill the definition of protected medication record and defines the term sensitive health services to include reproductive health services other than abortion care. Amendment number 4 specifies that the section of the bill governing disclosure by health information exchanges does the following. Begins December 1 of this year. Applies to disclosures of health information to recipients located in the state and outside the state and to electronic health networks. And either rather than applying to a protected services record or protected medication record, applies to mifepristone data or the diagnosis, procedure, medication, or related codes for abortion care and other sensitive health services as determined by the Secretary of Health. This amendment also makes penalties for disclosures applicable beginning June 1, 2024, and requires the Secretary to determine codes that are subject to disclosure restrictions and adopt regulations to restrict the disclosure of that information. Amendment number 5 removes from the bill language that would have authorized a health care provider to disclose a medical record under certain circumstances and removes from the bill proposed language relating to authorized disclosures to other health care providers. Amendment number 6 removes from the bill provisions that would have established that certain provisions of law relating to refusals to disclose medical records do not apply to violations of the bill. Amendment number 7 establishes a protected health care commission to make recommendations to the Secretary of Health on sensitive health services to be legally protected health care. Amendment number 8 removes from the bill language that would have prohibited dispensers from submitting certain information to the state-designated exchange. The final amendment requires the Secretary of Health to adopt emergency regulations within 90 days after the effective date of the bill to identify diagnostic, procedure, medication, and related codes for abortion care. Requires MHCC to adopt emergency regulations within 9 months after the effective date of the bill to implement the bill's prohibitions on health information exchanges and electronic health networks from disclosing data. Requires MHCC to report quarterly in fiscal years 24 and 25 to the Senate Finance Committee and the House Health and Government Operations Committee on the status of implementation of the prohibitions on health information exchanges and electronic health networks disclosing data, and alters the effective date of the bill. Move the amendments.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed? The ayes have it. Amendments have been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any amendments to the bill or to its title? Seeing none, the bill is ordered printed for third reading. Report of the Committee on Ways and Means, report number 15. Clerk will read the first bill.
House Bill 448, non-public education, special education placements, renaming, and teacher salaries, Teacher Pay Parity Act. Favor of the amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. Move so much be considered the reading of the amendments.
So ordered.
Amendment number 1 is technical. Amendment number 2 strikes provisions in the bill renaming placements of children with disabilities as special education placements and provisions altering the cost share between the state and county needed to pay for those placements, and requires each non-public school with placements to share teacher salary information with county boards of education in order to create teacher pay equity. Move the amendments.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed? The ayes have it. The amendments have been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. The favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read the next bill.
House Bill 529, gaming, video, lottery terminals, local impact grants, Baltimore City. Favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Thank you. Opposed? No. The ayes have it. Favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read the next bill.
House Bill 867, Baltimore City, collection of unpaid property taxes. Favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read the next bill.
House Bill 921, property tax, in rem foreclosure. Favor of the amendments. Amendment number 1.
Madam Speaker.
Recognizing the floor leader.
Thank you, Madam Speaker. Move so much be considered the reading of the amendment.
So ordered.
The amendments strike the bill as written and recodify the bill as a new section of law applicable only to Baltimore City. Ensure the bill meets constitutional requirements by requiring Baltimore City to compensate a former property owner and any other interested parties when it forecloses on a property by either selling the property at auction and distributing the proceeds to the former owner and any other interested parties, or compelling an assessment of the property and paying the former owner and any other interested parties the difference between the assessment and the amount of the outstanding tax liens, and makes technical and clarifying changes. Move the committee amendment.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed? The ayes have it. The amendment has been adopted. The question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. The favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read the next bill.
House Bill 947, Charles County property tax credit for volunteer emergency responders. Favor of the amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. Move so much be considered the reading of the amendment.
So ordered.
The amendment changes the maximum income to be eligible for the credit from $50,000 to $150,000. Move the committee amendment.
The question for the House is the adoption of the amendment. All in favor signify by saying aye. Opposed? The ayes have it. The amendment has been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read the next bill.
House Bill 1237, special education, judicial actions, attorney's fees, and related costs. Favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Report of the Committee on Ways and Means, report number 16. Clerk will read the first bill.
House Bill 492, Anne Arundel County school vehicles, duration of operation. Favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. The favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read next bill.
House Bill 648, Garrett County Tax Sales Auctioneer Fees, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read next bill.
House Bill 656, Talbot County Board of Education Election of Officers, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. The favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read next bill.
House Bill 1096, Baltimore County Property Tax Exemption, real property owned by fire company or rescue squad. Favor of the amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. Move so much be considered the reading of the amendments.
So ordered.
The amendments limit the exemption to property that is currently used by a fire company or rescue squad or is not currently used for any purpose but will be used by a fire company or rescue squad in the future. Move the committee amendments.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed? The ayes have it. The favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading.
Sticker with Lays.
Report of the Committee on Ways and Means, report number 17. Clerk will read first bill.
House Bill 175, Baltimore County Board of Education student member voting. Favor of the amendments. Amendment number 1.
Madam Speaker,
Recognizing the floor leader.
so much be considered the reading of the amendments.
So ordered.
Amendment number 1 is technical. Amendment number 2 requires that members of the Baltimore County Board of Education and the leadership of the school system establish a budget training for the student member of the board to take prior to voting. Move the amendments.
Question before the House is the adoption of the amendment. All in favor signify by saying aye. Opposed? The ayes have it. The amendment has been adopted. The question now is the adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none. The bill is ordered printed for third reading. Clerk will read the next bill.
House Bill 210, Baltimore County Board of Education member elections and appointments. Favor of the amendments. Amendment number 1.
Madam Speaker,
Recognizing the floor leader.
so much be considered the reading of the amendment.
So ordered.
The amendment replaces the sponsor's name with that of the delegation. Move the amendment.
Question for the House is the adoption of the amendment. All in favor signify by saying aye. Opposed? The ayes have it. The amendments have been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read next bill.
House Bill 231, Baltimore City Property Taxes, authority to set special rates. Favor of the amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. Move so much be considered the reading of the amendment.
So ordered.
The amendment allows Baltimore City to set a special property tax rate for vacant and abandoned property only. Move the committee amendment.
The question before the House is the adoption of the amendment. All in favor signify by saying aye. Opposed? The ayes have it. The amendment has been adopted. The question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. The favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read next bill.
House Bill 249, Baltimore City Property Tax, retroactive exemption. Favor of the amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. Move so much be considered the reading of the amendment.
So ordered.
The amendments make the bill an emergency bill, require a report on exemptions granted, and sunset the bill on December 31st, 2026. Move the committee amendments.
Question for the House is the adoption of the amendment. All in favor signify by saying aye. Opposed? The ayes have it. The amendment has been adopted. The question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read next bill.
House Bill 348, Baltimore County School Board Nominating Commission Vacancy Procedures. Favorable amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. So much to be considered the reading of the amendments.
So ordered.
The amendment removes the sponsor's name and substitutes that of the delegation. Move the amendment.
Question for the House is the adoption of the amendment. All in favor signify by saying aye. Opposed? The ayes have it. The amendment has been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. This side, you are quiet over here. It's both sides of the chamber. Okay. Let's do this again. Question now the adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. The favorable report is adopted. Very good. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read. Report of the Committee on Ways and Means, report number 18. Clerk, read first bill.
House Bill 153, Baltimore City Board of School Commissioners, Student Members, and Task Force to Study Compensation and Student Members. Favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read next bill.
House Bill 222, Baltimore County and Frederick County Career Activities in Public High Schools, Sale of Coffee by Students with Individualized Education Programs. Favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. The favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read next bill.
House Bill 247, St. Mary's County Transfer Tax Sunset Extension. Favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. The favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read next bill.
House Bill 402, Kent County Board of Education Student Member. Favorable amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. So much to consider the reading of the amendment.
So ordered.
The amendment removes the sole circumstance in which student member of the board can attend an executive session. I move the amendment. I move the amendment.
Okay. Question for the House, the adoption of the amendment. All in favor signify by saying aye. Opposed? The ayes have it. The amendment has been adopted. The question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read next bill.
House Bill 1079, Prince George's County Board of Education and School System Revisions and Local Public Campaign Finance for Board of Education Members. Favorable amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. So much to be considered the reading of the amendments.
So ordered.
Amendment number 1 is technical. Amendment number 2 puts a minimum age limit on non-student Board of Education members, adds another duty to those enumerated for the chair of the County Board of Education, and removes references to the county superintendent. Amendment number 3 clarifies that the equitable distribution of funds to schools does not supersede the state requirements and strikes provisions related to the Office of Accountability and Compliance. Amendment number 4 specifies the content of the procedures for the election of a student member, alters the compensation for the chair of the county board, strikes provisions related to the campaign financing, and makes the act contingent on another Prince George's County delegation bill. Move the amendments.
Question before the House is to move the amendments. All in favor signify by saying aye. Aye. Opposed? Ayes have it. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk, report of the Committee on Ways and Means, report number 19. Clerk will read the first bill.
House Bill 432, Prince George's County Chief Executive Officer of the Public School System Search Committee Requirements. Favorable amendments. Amendment number 1.
Recognizing the floor leader.
Bouncing up and down a bit today. So much be considered the reading of the amendments.
So ordered.
Amendment number 1 is technical. Amendment number 2 renames the chief executive officer of the Prince George's County Public School System, that makes them the county superintendent, provides the appointment of the members of the search committee that selects the county superintendent, and makes the bill an emergency measure. Move the amendments.
Question for the House is adoption of the amendments. All in favor signify by saying aye. Opposed? The ayes have it. The amendments have been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill as to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read next bill.
House Bill 437, Prince George's County Public Schools, Office of Integrity and Compliance Establishment. Favorable amendments. Amendment number 1.
Recognizing the floor leader.
Thank you again, Madam Speaker. So much be considered the reading of the amendments.
So ordered.
The amendment alters the title of the Chief Executive Officer of Prince George's County Public School System to be the County Superintendent and to align the bill with HB 432. Move the amendments.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed? The ayes have it. The amendments have been adopted. The question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read next bill.
House Bill 444, Prince George's County Payment in lieu of Taxes Agreements, Low-Income Housing. Favorable amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. Move so much be considered the reading of the amendment.
So ordered.
The amendment allows the county to enter into a payment in lieu of taxes agreement for any project that provides rental housing for low-income persons. Move the committee amendment.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed? The ayes have it. The amendments have been adopted. The question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. The favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read next bill.
House Bill 1078, Prince George's County Property Tax Credit, Offset of Annual Tax Increases. Favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Report of the committee. Report of the Committee on Appropriations, report number 9. Clerk will read the first bill.
There's a 9. Okay. Yeah. House Bill 372, Higher Education, Veterans of the Afghanistan and Iraq Conflict Scholarship, altering name of scholarship. Favorable.
The question before the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. The favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read the next bill.
House Bill 629, Higher Education, Edward T. Conroy Memorial Scholarship Program, Surviving Spouses of Service Members. Favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Report of the Committee on Environment and Transportation. Report number 8. Clerk will read the first bill.
House Bill 11, Private Well Safety Act of 2023. Favor of the amendments. Amendment number 1.
Recognizing Vice Chair of the Committee.
Thank you, Madam Speaker. So much be considered the reading of the amendments.
So ordered.
Amendment number 1 makes technical changes. Amendment number 2 strikes language establishing a private well safety program and fund and related references, requires the department to adopt regulations under the bill by a certain date, and makes the establishment and implementation of the online portal subject to the availability of funding. Move the amendments.
Question before the House is the adoption of the amendment. All in favor signify by saying aye. Opposed? The ayes have it. The amendments have been adopted. The question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read the next bill.
House Bill 12, Equitable and Inclusive Transit-Oriented Development Enhancement Act. Favorable amendments. Amendment number 1.
Madam Speaker.
Recognizing the floor leader.
Thank you, Madam Speaker. Move so much be considered the reading of the amendments.
So ordered.
As amended, House Bill 12 establishes the Transit-Oriented Development TOD Capital Grant and Revolving Loan Fund and its purpose, funding sources, and authorized uses. Amendment number 1 is technical. Amendment number 2 substitutes the Smart Growth Subcabinet for DOT as the state entity responsible for partnering with local jurisdictions to designate TODs. Amendment number 3 specifically includes funds from the Complete Streets program as state development and infrastructure for which TOD may apply. Amendment number 4 establishes that a TOD designation applies for 10 years subject to a potential 10-year extension. And amendment number 6 reduces the fund balance for which the mandated appropriation is required to maintain from $10 million to $5 million. Move the amendments.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed? The ayes have it. The amendments have been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read the next bill.
House Bill 150, Housing and Community Development Adaptive Reuse. Favorable amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. Move so much be the reading of the amendment.
So ordered.
As amended, the bill establishes an adaptive reuse of property to develop affordable multifamily housing is an eligible use of the proceeds of a loan for a specified housing program administered by DHCD. It requires DHCD to notify applicants of certain programs to be for adaptive reuse of a property to develop affordable multifamily housing as an eligible use of the loan proceeds. The subcommittee amendment amends the DHCD does not need to notify applicants of a loan that adaptive reuse is an eligible use of loan proceeds as required under the bill if the program does not focus on housing production. Move the amendments, Madam Speaker.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed? The ayes have it. Amendments have been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. The favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read the next bill.
House Bill 151, Real Property Residential Leases, Notification of Rent Increases. Favorable amendments. Amendment
Recognizing the floor leader.
Thank you, Madam. Thank you, Madam Speaker. Move so much be the reading of the amendments.
So ordered.
As amended, the bill requires a landlord to notify a tenant in writing if the landlord intends to increase a tenant's rent during a subsequent term of the tenancy. Notice must be provided by first-class mail with a certification of mailing, or if elected by the tenant, sent by electronic delivery. A landlord may not condition the acceptance of the lease application of a tenant's election to receive notice of the rent increases by electronic delivery and use a lease or form of lease containing the provision that requires a tenant to accept notice of rent increases by electronic delivery. The notification provision in the bill does not apply to a landlord who provides a tenant with a written notice of the intent to terminate the tenancy. The bill also requires a certain report of local governments to adopt certain policies related to the residential units. Move the amendments, Madam Speaker.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed? The ayes have it. Amendments has been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Gentleman from Baltimore County.
Thank you, Madam Speaker. Can I please ask the floor leader a couple questions?
Floor leader.
Yes, sir.
Thank you. You went through that one part really quick, and I didn't quite pick it up. All right, so if you want to email a tenant that you're going to increase the rent by 4%, you can do that. Is that they have to opt in for that? Am I correct?
You are partially correct.
Okay.
There is no reference in the bill. There is no reference in the bill any longer about 4%, and there's no reference in the bill any longer about 4%. The election for electronic is an or, so you can do first-class mail or you can do the electronic notification.
Okay, since you removed the 4%, is there a limit? So if you want to raise the rent 1%, do you still have to notify them 120 days?
No. There's nothing in the bill that suggests that there is a rent increase percentage any longer at all. It's just like when you send a notice to quit. If you have a tenant in a home, you send them a notice to quit. This is a similar, exact same kind of notice procedure. If you look at the real estate article, you see, I think it's 8-402. It talks about the notification requirements to quit a tenant. The same language that is in the notice to quit in Article 8-402 is the same language that's in this provision here.
Okay, thank you. The last question is, I know with our real estate contracts, we already have language in there that says that you must fill in the date, 30 days, 60 days to give the tenant notice. Is that going to affect that notice?
Again, if you look at Article 8-402 in terms of notification for the tenants, none of that has changed in this bill.
All right, just to clarify one last time, so you can email them, you don't have to send a first-class mail, correct?
The language says or.
Or. All right,
They
thank
elect.
you.
The tenant must elect.
So they have to opt in.
Have to opt in.
Okay, that's why there was a question I had to ask. Thank you. Thank you, Madam Speaker.
Yes. Gentleman from Eastern Shore.
Thank you, Madam Speaker. And would it be okay to special order the bill? That was a lot, and
I will allow a special order to the end of today.
that'd be fine. Thank you.
Question before the House is a special order. House Bill 151 until the end of, what time is that now? Until the next.
First session.
Second session.
Second session. Okay, thank you, Madam
Second
Speaker.
All in favor signify by saying aye. The ayes have it. The bill has been special ordered. Clerk will read next bill.
House Bill 219, St. Mary's County Motor Vehicle Registration, exception for golf carts. Favorable amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. Move so much to be considered the reading of the amendments.
So ordered.
As amended, HB 219 requires the St. Mary's County Board of County Commissioners to generate a report recommended and describing the areas of St. Mary's County that the County Board considers appropriate for the operations of unregistered golf carts on public highways, subject to the standards established in the bill. The amendments are the bill. Move the amendment.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed? The ayes have it. The amendments have been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read next bill.
House Bill 331, Real Property Cooperative Housing Corporations, Condominiums, and Homeowners Associations, Virtual Meetings. Favorable amendments. Amendment number 1.
Recognizing the floor.
Thank you, Madam Speaker. Move so much be the reading of the amendment.
So ordered.
The bill establishes additional requirements for virtual meetings that are held by corporate housing corporations, condominiums, or homeowners associations. Authorizes the person conducting a meeting or the person's designee to take specified actions during a meeting, including removing a participant from the meeting under certain circumstances. Amendment number 1 is technical. Amendment number 1 specifies that a meeting of a governing body held by electronic transmission may only be held in accordance with existing applicable meeting requirements. Move the amendments, Madam Speaker.
Question before the House is the adoption of the amendments. All in favor signify by saying aye. Opposed? The ayes have it. The amendment has been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read next bill.
House Bill 391, Vehicle Laws, Parking Enforcement, Citations. Favorable amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. May so much be considered a reading of the amendments.
So ordered.
The first committee amendment includes third-party contractors as subject to the bill, and the second requires verification instead of investigation. Move the amendments.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed? The ayes have it. The amendments have been adopted. Question now is the adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. The favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read next bill.
House Bill 561, Town of Mount Airy, Carroll County and Frederick County Urban Renewal Authority. Favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. The favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read next bill.
House Bill 612, Natural Resources, Licensed Tree Experts, Alterations. Favorable amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. Be so much consider the reading of the amendment.
So ordered.
Thank you, Madam Speaker. As amended, the bill makes various changes to provisions governing licensing of tree experts related to 1, penalties for engaging in the work or business of a tree expert without a license. 2, the ability of a person to physically engage in treatment, care, or removal of trees for compensation under another person's tree license, expert license. And 3, insurance requirements applicable to a licensed tree expert. Amendment authorizes a person to work under a tree expert's license if the person, 1, employs a licensed tree expert who can provide oversight, 2, is employed by a company that employs a licensed tree expert who can provide oversight, or 3, is a licensed tree expert. Move the amendments.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed? The ayes have it. The amendments have been adopted. The question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. The favorable report is adopted. Are there any additional amendments to the bill or to its title? Recognizing the gentleman from the Eastern
Thank you, Madam Speaker. And I don't have an amendment, but I do have a question for the floor leader.
Absolutely.
Floor leader.
Is there anything in this bill that would address like a natural disaster? So we have had, tornadoes, and we've had situations where there were a lot of downed trees, especially over the last several years.
As I understand it, this bill does not include a person engaged in commercial logging or timber harvesting, a person engaged in the installation of underground facilities or associated site construction, a person who treats, cares, or removes trees that is 20 feet tall or less.
Okay,
And
so
it
if we have a natural disaster and they
it should
need
not
more
affect
people,
them at all. Nope.
So someone without a license during a natural disaster could provide this service without a license? Because we don't have enough tree experts in the state in many cases, especially if it's a...
They would more than likely work under a tree expert's license.
Okay, actually, could we special order this bill? I think there should be an exemption for folks during a natural disaster because we really do have a shortage.
There's actually no need for an exemption because they would not be halted from doing that type of work.
Okay, so
but the utility companies would bring them in.
So on short notice, folks would have to find a tree expert and work under their license. Is that what you're saying?
The utilities would bring them in. Yeah. The utility companies.
All right, that's okay. We can move
What would
on.
you like to do, sir?
We can move on. Thank you.
Okay.
Chairman of the committee.
We would accept a special order until the second session, but I want you to know that if usually in a storm, the tree branches would be on the ground, and there's no need for a tree expert in that instance. Usually they're cleaning up debris that's already fallen down. Tree experts are really needed more in the instance of a tree that is, I believe, more than 4 feet in height. 20 feet in height. So if a tornado goes through your community and destroys a lot of trees and they're blocking the road, picking all that up does not require a tree expert. Having said that, if you still want me to special order the bill into the second session.
My guess is you probably won't accept the amendments. I think we'll just move forward. We can move forward without the amendment.
Okay.
That's not, yeah.
Thank you.
Okay. Are there any additional amendments to the bill as to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read next bill.
House Bill 624, Environment, Suppliers of Water, Notification Requirements. Favor of the amendments. Amendment number 1.
Recognizing the Vice Chair of the Committee.
Thank you, Madam Speaker. So much be considered the reading of the amendments.
So ordered.
Amendment number 1 makes technical changes. Amendment number 2 makes the bill's requirement to provide at least 3 means of notice apply only to certain water suppliers serving at least 3,300 customers. Amendment number 3 clarifies that water suppliers must only provide notice under the bill to MDE and the Maryland Department of Emergency Management of a confirmed positive test for E. coli, alters existing notification requirements, including by making requirements consistent with public notification requirements under the Safe Drinking Water Act, and expanding certain notification requirements relating to MTBE. Move the amendments.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Aye. Opposed? The ayes have it. Amendments have been adopted. The question now is the adoption of the favorable report as amended. All in favor signify by saying aye. Aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read next bill.
House Bill 671, Garrett County Board of County Commissioners, meetings. Favorable amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. House Bill 671 is recommended favorable with amendment. Move so much be considered the reading of the amendment.
So ordered.
Amendment number 1 is technical. Amendment number 2 authorizes the public meetings to be live streamed rather than over video broadcast, and prohibits, in the absence of a formal declaration of a state of emergency, that the Board of County Commissioners for Garrett County from meeting solely through live stream for more than 2 consecutive meetings. Move the amendments.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Aye. Opposed? The ayes have it. The amendments have been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read next bill.
House Bill 691, Landlord and Tenant, failure to repair serious and dangerous defects, Tenant Remedies, Tenant Safety Act. Favorable amendments. Amendment 1.
Recognizing the floor leader.
Thank you, Madam Speaker. Move so much be considered the reading of the amendments.
So ordered.
As amended, this bill does 2 things. 1, it codifies something called the implied warranty of habitability. And number 2, it makes it slightly easier for vulnerable Marylanders to require their landlords to fix problems in their homes that seriously threaten their life, health, or safety. Amendment number 1 is technical. Amendment number 2 adds to the list of defects which represent a serious and substantial threat to the life, health, or safety of the tenant. Amendment number 3 clarifies the duties and relief for tenants. Amendment number 4 removes monetary damages from the bill. Amendment number 5 requires tenants to pay into separate escrow accounts. Amendment number 6 addresses preemption issues with local jurisdictions. Amendment number 7 alters notice provisions. Amendment number 8 addresses what happens when a lead petitioner leaves or is removed from the action. And Amendment number 9 clarifies that the lead petitioner is not practicing law. Move the amendments.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Aye. Opposed? The ayes have it. The amendments have been adopted. The question now is adoption of the favorable report as amended. All in favor signify by saying aye.
Madam Speaker.
Opposed? The ayes have it. The favorable report is adopted. Are there any additional amendments to the bill or to its title? Gentle lady from Anne Arundel. There's a process when I call on you.
Yes, ma'am. Thank you, Madam Speaker. There is a lot in this bill, and that was a lot of amendments. Would it be possible to special order this bill until the appropriate time tomorrow for a possible amendment after I go through all the amendments that...
We would happily accept a special order to the second session today.
Okay. Thanks so much.
Okay. Question for the House is to special order House Bill 691 into the second session today. All in favor signify by saying aye. Opposed? The bill has been special ordered. Clerk, read the next bill.
House Bill 710, Anne Arundel County Speed Monitoring Systems, Residential Districts, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read the next bill.
House Bill 820, Montgomery County Speed Monitoring Systems, Maryland Route 200 Inter-County Connector. Favor of amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. As amended, HB 220 requires MDTA to 1, place 4 devices that display a real-time posting of the speed at which a driver is traveling along each roadway on Maryland 200, 2, increase speed limit enforcement efforts, and 3, collect data on speed violations on Maryland Route 200. The amendments are the bill. Move the amendments.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed? The ayes have it. The amendments have been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. The favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read the next bill.
House Bill 887, St. Mary's County Metropolitan Commission, new facilities, favorable.
The question before the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. The favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read the next bill.
House Bill 1004, Wacomico County Sanitary District, authorization, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read the next bill.
House Bill 1173, Motor Vehicles, Recreational Vehicle Dealer Agreements, favorable amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. As amended, House Bill 1173 establishes a new regulatory framework that applies to recreational manufacturers and dealers, and it generally provides for a new MVA licensing scheme for RV manufacturers whose vehicles are sold in the state. Move the amendments.
Question before the House is the adoption of the amendments. All in favor signify by saying aye. Opposed? The ayes have it. The amendments have been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read the next bill.
House Bill 1194, Town of Sharpsburg, Parking of Vehicles Restrictions, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read the next bill.
House Bill 1253, Vehicle Laws, Lighting, Privately Owned Vehicles of Volunteer Fire Company Members, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Report of the Committee on Judiciary, report number 14. Clerk, read first bill.
House Bill 1032, Criminal Procedure, Protection of Identity of Minor Victim, favorable.
Question before the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read the next bill.
House Bill 1077, Department of State Police, reproducing or distributing logo for commercial purposes, prohibition, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read the next bill.
House Bill 1175, Criminal Procedure, Hunting Offenses, expungement, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it.
Madam Speaker.
Favorable report is adopted. Are there any amendments to a bill or to its title? Chairman of the committee.
Thank you, Madam Speaker. I have a question for the bill sponsor.
Bill sponsor.
Good morning.
Good morning.
What does this bill do?
Thank you for the question.
You're very welcome. But what does this bill do?
This bill expands eligibility for expungements of a police record or court record or other record maintained by the state or political subdivision of this state to include a conviction for 8 of the misdemeanor hunting-related offenses listed in the bill and described in further detail in the fiscal note.
That seems like something we've been working on for quite some time. It seems like a great bill. Thank you very much.
Thank you.
Are there any amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Report of the Committee on Judiciary, report number 13. Clerk will read the first bill.
House Bill 42, Courts, Judgments, Exception from Execution, favorable amendments. Amendment number 1.
Madam Speaker.
Recognizing the floor leader.
Thank you, Madam Speaker. Move so much be considered the reading of the amendments.
So ordered.
Amendment number 1 is technical. Amendment number 2 clarifies the definition of depository institution and value, clarifies and provides additional procedures a depository institution must follow, and clarifies the exemptions under the bill. Move the amendments.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed? The ayes have it. The amendments have been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk will read the next bill.
House Bill 193, Probation Before Judgment, Probation Agreements, favorable amendments. Amendment number 1.
Recognizing the chair of the committee.
Thank you, Madam Speaker. Move so much be the reading of the amendments.
So ordered.
Amendment number 1 adds sponsors and makes technical changes. Amendment number 2 authorizes the entry of probation before judgment pursuant to an agreement between the state and the defendant in which the defendant pleads not guilty and the court finds facts justifying a finding of guilt. Move the amendment.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Opposed? The ayes have it. The amendments have been adopted. The question now is adoption of the favorable report as amended. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill or to its title? Recognizing Minority Whip.
Thank you, Madam Speaker. I just have a couple questions for the chair, if you would. So it's deja vu here.
Committee Chair.
Yeah.
Good morning.
So I was reading through the bill, just for everyone's, I guess, my own edification, everybody else's edification. Generally in Maryland, with the probation before judgment, it kind of requires you to at least plead guilty, right? Admit guilt to some extent, which could then trigger automatic deportation. Is that fair to say?
What happens when you plead in any way is the court will hear a statement of facts. The court will say that those facts would justify a finding of guilt, and then they say, and I find you guilty. Then they go into the sentencing stage of the process, and the court can decide whether or not right now to give a probation before judgment or not. This would make create another way to go forward.
So it looks like the intent of the bill, prior to the amendments at least, is to figure out a way where someone can go on probation without having to at least admit guilt, so that wouldn't automatically violate some sort of rule that would lead to an automatic deportation. And I was reading through the amendments. It's like nine amendments. So my question is, and I'll try to just synthesize this better, but with the amendments, does the bill now create a situation where someone can be automatically deported with a probation before judgment? So currently, with a probation before judgment, current law, you have to admit guilt. And when you do that, it's automatic grounds for someone to be deported. With these amendments, the 9 amendments that were added, is that still the case?
Not sure that I think I understand. I understand your question, but the issue here is more with regard to deportation, is that they are found guilty, that they are found guilty and they're convicted, and even for a half a second found guilty, while they then go to the sentencing process, and it could be just as quick as that, and then they're given a probation before judgment right now, at least as it stands, and then that conviction is effectively wiped off of their record. So they would go forward, and again, under the bill that now we've run it by the State's Attorneys Association, the Judiciary, everybody is on board. It requires the state's attorney to consent to doing this. It takes affirmative consent from the state's attorney to go forward in this way. They have to agree, and then the court can go all the way up to the line and basically say, take the facts that happened, and the court can just say, I find that the facts justify that the person would be guilty, and then they stop, short of saying they are guilty.
Okay. All right. Thank you, Mr. Chairman. I appreciate that. So just what it says is you no longer have to admit guilt. You may have to admit facts, which could be inferred, but you don't have to admit guilt, and that possibly could have some sort of different ramifications as it pertains to deportation. So thank you, Mr. Chair.
And at this point, there are ways that you can put in, that you can go forward, like an Alford plea, and other ways where they don't accept that the facts, they don't admit to the facts, and still we go forward with a plea.
Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read next bill.
House Bill 859, Criminal Law, Private Home Detention Monitoring, Notification. Favor of the amendments. Amendment number 1.
Recognizing the committee chair.
Thank you, Madam Speaker. Move so much be the reading of the amendments.
So ordered.
Amendment number 1 adds sponsors and makes technical changes. Amendment number 2 alters the notification protocol that a private home detention monitoring agency must follow when a defendant absconds, prohibits a person who is monitored by a home detention monitoring agency from violating a condition of pretrial release, and establishes a work group on home detention monitoring. Move the amendments.
Question for the House is the adoption of the amendments. All in favor signify by saying aye. Aye. Opposed? The ayes have it. The amendments have been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Aye. Opposed? The ayes have it. The favorable report is adopted. Are there any additional amendments to the bill or to its title? Hearing none, the bill is ordered printed for third reading. Clerk, read next bill.
House Bill 1191, Task Force on Preventing and Countering Elder Abuse. Favor of the amendments. Amendment number 1.
Recognizing the floor leader.
Thank you, Madam Speaker. Move so much be considered the reading of the amendments.
So ordered.
Amendment number 1 adds sponsors. Amendment number 2 adds members to the task force. Move the amendment, Madam Speaker.
Question before the House is the adoption of the amendments. All in favor signify by saying aye. Aye. Opposed? The ayes have it. The amendments have been adopted. Question now is adoption of the favorable report as amended. All in favor signify by saying aye. Aye. Opposed? The ayes have it. Favorable report is adopted. Are there any additional amendments to the bill to its title? Hearing none, the bill is ordered printed for third reading. Laid over calendar number 2. Clerk will read the bill.
House Bill 283, Maryland Medical Assistance Program, Gender Affirming Treatment, Trans Health Equity Act. Favor report is amended, adopted. Amendment number 1.
Recognize the gentleman who asked for the layover.
Thank you, Madam Speaker. I appreciate the opportunity yesterday to have laid this bill over so that the members could read the bill. I don't know if the committee has had an opportunity to review the amendment. Maybe I can yield to them first before I continue.
Committee Chair.
Thank you, Madam Speaker, and good morning, everyone. Thank you for the courtesy. The committee has had an opportunity to review it, and the floor leader is ready to address it when you're ready. Thank you. Thank you, Madam Speaker.
Thank you, Madam Speaker. Then, if I may, Madam Speaker, I would like to ask the floor leader some questions.
Floor leader.
Thank you, Madam Speaker.
Good morning. Has the amendment been considered, accepted, or rejected?
The amendment has been considered and has been rejected.
Okay, so under current, some questions then, if I may. Under current Medicaid requirements in Comar in Maryland, it says that services can be provided to individuals 18 years of age and older. This bill, I think you have indicated previously in the voting session, was going to codify Comar, but it doesn't include the 18 and older. So does this bill then apply to children?
Currently, Medicaid provides some gender-affirming care for children. So that already is happening. What's not happening is a number of different services that particularly apply to adults are not being offered.
Okay, so would one of those, thank you for that, would one of those, and I'm reading from the gender transition services under the Maryland Medicaid program, it says here, the individual is at least 18 years of age, and the individual has capacity to make fully informed decisions and consent for treatment. That's currently in Comar, and I'm reading directly from the document.
You are reading directly from the document. We do have information from the Medicaid office that gender-affirming care is being offered to children.
So is a vaginectomy offered to children in Maryland, and would this bill allow that?
No.
That's not so, because it says it right here. If we're eliminating the 18 years of age requirement, which that's what this bill does, then from a female to male transition of a child, a vaginectomy would be permitted, because we're removing the 18 years of age requirement.
So let me back up just a bit around how these decisions are made.
Can I ask you a question, though? What is a vaginectomy?
Can I answer? I'm going to answer your question, but I need for the body to understand, because out of context, you know, the answer sounds different than what the true spirit and intent is. So the context is the decisions about what medically necessary and medically indicated gender-affirming care is appropriate at any point after the gender dysphoria diagnosis is made by, if the person is under 18, it's made by the patient. The parent is required. The parent is a required part of this process, and the medical provider. So in those rare, extremely rare circumstances where the patient, the parent, and the medical provider believe that it might be necessary, medically, not believe, know that it's medically necessary and indicated to proceed with surgery, then they will make the decision to do that. That's what this bill allows.
So this bill, House Bill 283, would allow a vaginectomy, and I'm going to ask again, what is a vaginectomy of children I'm talking about? Because we're removing the 18 years of age and older requirement.
It's not something that we would do in children.
But
unless there was cancer or some other medical condition that would cause that.
That's not, I'm sorry, but that's not so. Under the Maryland Medicaid program, and this bill specifically states that it would apply to people under the age of 18, which are children, and here are the services, and those services can and shall be provided pursuant to all of the things that you just said, one of them being a vaginectomy.
So I'm going to go back to medically necessary, indicated, and consistent with the standards of care. This is not in any way, a decision that is being made impulsively.
So a male to female transition, there is the belief by certainly those who have put their names behind House Bill 283. I just want to be clear that children are capable of making the decisions to have male to female transition for a vaginectomy, a hysterectomy, a mastectomy, an ovurectomy. If any of these items were truly medically necessary, they would be done for the health of the individual. But that's not what the purpose of this is. This is not about health. This is about male to female transition and female to male transition of children. So what is a vaginectomy?
It's a removal of the vagina.
Of a child.
We're not talking about children, though. We are talking about, and I just need to go back to, no child, this bill in no way says that a child can make an independent decision about what kind of care they need, including gender-affirming surgery.
In the bill it says, and I'm reading from the bill, alterations to the genitals and gonads, laser treatment for scars and gender-affirming treatment, alterations to the abdomen, chest, trunk, and buttocks. And it just goes on and on. This is from the bill.
Right.
The bill matches the gender transition services under the Maryland Medicaid program, which includes a vaginectomy, which the bill clearly says would be something that could be done at taxpayer expense for children under the ages of 18. So what is a vaginectomy, since that is in the bill?
So the bill is allowing it under the extreme circumstances. Just because it's in the bill doesn't mean it's going to be done. That's number one. But number two, I'm just going to go back to, and you're going to, I think, get tired of hearing me say, medically necessary and indicated for the health of the individual. I disagree with you, sir, when you said this is not about health. This is absolutely about health. And yesterday, you referenced that this is a very serious bill. I totally agree with you that this is a very serious bill. It is especially serious for the 6,000 transgender people on Medicaid who do not have the available services currently available to them under our Medicaid program, when people who can afford commercial insurance have all of those options available to them to make themselves healthy and whole.
And those 6,000 people are over 18. They're 18 years of age or older. We're talking about children here, and I really want to keep the focus to that because that's what this bill is. This bill is applying what adults are doing to themselves, and they are adults, and they get to make those decisions because they are adults, to children. Among other things, a palloplasty, and I could very well be saying it wrong, scrotoplasty, a placement of testicular prostheses, mastectomy, children, male to female transition, a penectomy, a clitoroplasty, a labioplasty, a vaginoplasty. And it's further my understanding that it would also include puberty blockers for children. Is that so?
Puberty blockers are currently used
Not on
by
children.
Medicaid. Yes, they are.
Not for transitioning. So it says here hormone therapy, hormone blockers, and puberty blockers, which is a dead giveaway that it's for children. So my question is, isn't it so that there is an enormous loss of bone capacity and bone density as a result of putting children on puberty blockers?
The answer, sir, I'm being told, and the research says no, that's not true.
So there is an enormous amount of research and data, and it is indeed so that by putting children on these drugs, we are ruining their bone density. And I have the data here. I'm not going to read it because we can all read data, but it is so.
Okay. So, like many medications that we take, it may affect bone density, but if the medical provider who has prescribed, based on medical necessity and indication, the puberty blocker, then they would also supplement it with vitamin D and other supplements that would counteract that impact.
And I appreciate this, Madam Speaker. I do. I just have, I think, 2 more questions, and there are some others that do as well. Can you please tell me what a penectomy is?
It's right. It's the removal of the penis.
Of children.
Pardon?
Of children.
It is not specific to children.
The bill is. So can any of these, can that be reversed?
She answered your question.
Can this be reversed?
A penectomy?
Well, a child.
Yes. It is possible to do that, yes, to reverse that.
You can reverse it.
Yes.
So the removal of a penis can be, but it can be reversed, I presume, with what?
So surgeons currently reconstruct penises all the time for folks who identify as male and want to have that organ, or if it was damaged in some way. So yes, it is possible.
And so they're using cadaver penises. Is that so?
No.
That's not my understanding. So there are some other questions, Madam Speaker, and it's a serious matter, and I hear a lot of chatter, and it's an important issue to us. So I think that the members should listen closely.
Madam Speaker, may
Yes.
I ask, is the gentleman
Vice Chair.
moving his amendment?
Yes, the gentleman is moving his amendment, but there are a lot of other members in the caucus who do want to speak on this and the amendment and to ask you questions. And I do appreciate your patience. Thank you.
Okay,
and
thank
the chairman's patience as well.
Anyone else on the amendment has been discussed? Yes, go ahead.
Thank you, Madam Speaker. And could the floor leader please rise for some questions?
Perhaps I should just stay up now.
So I think you know me as a colleague, and when I stand, I've tried to be prepared, and I want to have a brief yet informative discussion for my purposes. And one of the things that I think happens when we have these debates on the House floor is a opportunity to learn more. And I want to tell you that what I'm getting ready to do and the questions I'm going to ask are built through the lens of, I wasn't going to stand on this bill yesterday, but because of the laying over procedure, it granted me the opportunity to print out the entirety of the bill file and to understand where it's coming from for the purpose of me having some concerns. So on the amendment, I pulled the study that was in your file, Gender Affirmative Care, a data-driven review of relevant academic literature. It was written by the University of Maryland, University of Kentucky, University of Amsterdam, University of Edinburgh. And the first question that I have for you goes to one of the early statements they make in this 70-some page document, which is that the Maryland and Ohio testimony, so on 2 different states, similar bill subjects, they say that the majority of witnesses for each state took opposite stances on gender affirmative care. So in Ohio, where they're trying to move restrictive legislation, they got a lot of anti-witness testimony that was in support of Ohio's position. And in Maryland, we had 95% of pro testimony on this subject, for which there was 4.5% against. And so what they're saying, The reasons for this are likely that the Maryland General Assembly is a supermajority Democratic body, and 2, witnesses were probably more inclined to submit testimony that aligned in substance with their personal positions on GAC. So to my question, since this is a highly partisan issue, witnesses who would not want to increase access to gender affirmative care may be discouraged from testifying in a majority Democrat legislature, and they will admit vice versa in Ohio. And the question I have for you and the committee is, do you feel that you had enough testimony for and against as you were advancing this policy when you have amendments like the one that we have here, which is a simple one, that's saying anybody under the age of 18 should not be access to this care? The question to the committee is, do you feel like you either solicited the kind of testimony that would help you have a better work product, or do you believe, as the report is suggesting, is that because it's a supermajority here in Maryland of the Democrat Party, that you won't find the kind of opposite testimony because it's so partisan, and this is a difficult subject matter to discuss?
Thank you for that question, and thank you for being a good friend, Delegate. So we are living in a wonderful age of technology when every bill that we are considering is available to the public. They can go online, they can see the text of the bill, they can they can offer testimony. All of the directions for how you offer testimony are posted on the website. We have in our committee many people who come to testify either in person or with written testimony. I would expect that minority legislators who are concerned that enough voices are not being heard can encourage their constituents to come to the hearing, to send us information that they think is important in formulating our opinion about the bill and in our voting decisions. So I think the process allows for great public engagement. And we in no way discourage people. I mean, our chair is in my opinion, the most welcoming chair I've ever met in terms of just making everyone feel welcome. So I think that I would disagree with you that it is simply because of the makeup of this body that we didn't hear. And it's not really related to the amendment.
So thank you, because I believe the same as you, that your committee chair is thoughtful and considerate. But back to the point, the position was not mine. It was one that the study, which was a pro study for this piece of legislation, identified. So the second question on the same study is that those who and this is 13% of the witnesses who either currently or previously identified as transgender, opposed expanding access to gender affirmative care. So what they're saying is that there is a large percentage, and 13%, that's 13 out of 100, who are or were transgender, are opposed to expanding this access to care. And I'm curious how you respond to that, as this is a work product, that surely this report was part of your deliberations. Did you incorporate that 13% and try to understand why somebody who's pro-transgender either was or is, but was against the principles of this bill?
Before you answer, is this on the amendment?
Of course
this
it is.
Amendment is on, that's currently
Madam
on the
Speaker,
board?
I started by saying I'm trying to have a reasonable conversation on a difficult subject, and I am headed somewhere. And
but is it on this amendment that
because the report goes
from Calvert? You know,
the report's going to position my concerns and why the amendment should pass, because the report does discuss under 18. So back to my question.
But did you answer my question though?
I did, but I'd like to have that answer.
Is it on this amendment?
It is.
How is it on this amendment? It seemed like you were going all over the place.
So when we talk to pro-transgender, Madam Speaker, so as we talk to pro-transgender or have been transgender who are opposed to expanding this access to care. I'm simply suggesting that those voices need to be heard, one, and then two, they do in this report, a 70-some page report, speak to the concern with children and access to this sort of care. So the question, Madam Speaker, does speak to this under the age of 18. And I'll be glad once she answers the question to go right to the study and why they have this issue and how they review the report.
So, first of all, we cannot know how people made those decisions about their care when they made them. And, you know, we hope, one of the things we want to do with this bill is provide all of the options and all of the information so that people who are looking for medically necessary and indicated health care are making the best decisions for themselves. And that's really important. But I want to be really clear about who is supporting this legislation. And I'm just gonna go down the line. It's the American Medical Association, the American Academy of Pediatrics, let me say that again, the American Academy of Pediatrics, the American Psychiatric Association, the American Psychological Association, the American Public Health Association, the American College of Physicians, the American Academy of Dermatology, the American College Health Association, American Heart Association, American Osteopathic Association, American Academy of Family Physicians, American Society of Plastic Surgeons, American College of Obstetricians and Gynecologists, the Endocrine Society, American Academy of Nursing, American Academy of Physician Assistants, American College of Nurse Midwives, American Counseling Association, American Medical Student Association, the Health Professionals Advancing LGBTQ Equality, American Nurses Association, National Association of Social Workers, National Association of Nurse Practitioners, the American Academy of Child and Adolescent Psychiatry. Let me say that one again. American Association of Child and Adolescent Psychiatry, National Commission on Correctional Health Care, Pediatric Endocrine Society, Society for Adolescent Health and Medicine, World Professional Association of Transgender Health, World Medical Association. And let's talk about folks right here in our state. So all of those folks are national, but right here in our state, Johns Hopkins Medicine Association for Transgender Health, the American College of Obstetrician and Gynecologists, the Chase Braxton Healthcare, Planned Parenthood, Healthcare for the Homeless, Johns Hopkins University Gertrude Stein Society, Mental Health Association of Maryland. I've got another whole page full, and I won't subject the body to it. But these are the people who are supporting this essential and medically necessary health care.
But on the amendment, they don't support under the age of 18. So to the speaker's...
yes, they do, sir. I'm sorry. I'm sorry to interrupt, but yes, they do.
Surgery? Do they support surgeries for under the age of 18?
When medically necessary and indicated, and in consultation and consent of patient, parent, and provider.
All right, so to the speaker's point, and the reason why I'm bringing up the report, which I've not heard you suggest that this report's wrong or inaccurate or delivering data that's not valuable to the committee. When asked on written testimony the question of capability of a trans youth to provide informed consent, 27 people or 27 versions of written testimony between Maryland and Ohio were against this position, and only 4 were for it. So the question is, how does the committee, and this is an honest question, what does the committee say when the vast majority of testimony seems to be against the capability of trans youth to provide informed consent?
We are looking at the being consistent with the standards of care and giving the providers and the patient and the parent all of the information, and it is informed consent. This does not happen without none of the gender affirming care happens without informed consent.
And so, Madam Speaker, the last one, and I'll just speak to the bill. The same report talks about the satisfaction, regret, and the reversibility of gender affirmative care, which I believe that the bill or the amendment sponsor spoke to. The reason why the report's important and why I wanted to spend a few minutes talking about that is because I had the opportunity when this bill was laid over to pull the entire bill file to understand where would I stand on a bill like this. I don't know where I would have voted, to be honest with you, had we not done that. And the report is instructive because it demonstrates that there's not consensus on the subject to the amendment, meaning that there's not consensus on whether folks under the age of 18 should be having the surgery done, and frankly, even if they're in a position to be able to make that decision for themselves, one could easily argue that a child who's growing up and is going through cycles of what it means to be an adolescent has a change of heart. And when you have surgeries, when you have procedures, when you're taking medicine that are aimed at changing who you are as a adolescent, this has to be something that can't just be a vote yes or no on. I think we should, as a legislature, with respect to the Speaker and to this legislature, consider whether or not somebody under the age of 18 should have this available. I saw the committee voting session on this. I don't think I'm the only one in the Republican Party that feels this strongly convicted concern for the children in this respect. These aren't the subjects that I normally stand on, and so for me to stand on a subject out of my jurisdiction, I do so because any Marylander who saw this debate and thought about this discussion would, I think, have the same opinion that I'm carrying, which is I understand why someone who under the age of 18 may or may not want or need the surgery, but we don't believe, Madam Speaker, that the science is settled on this, and I would ask that the body move the amendment, pass the bill, and pursue the subject in future years where maybe you have better discussions and incorporate some of the learning lessons of a 70-page report, of one of which was written by the University of Maryland. Thank you, Madam Speaker.
Madam Speaker.
The floor leader.
Thank you, Madam Speaker. So he mentioned the amendment. May I speak to the amendment?
Yes.
Thank you. I would ask the body to resist this amendment. There are several reasons. First of all, sometimes gender dysphoria is recognized in children. And let me give you the definition of gender dysphoria. And please note, it's a medical diagnosis. Right? So we are talking about health care here. So gender dysphoria is a clinically significant distress resulting from a marked incongruence between one's experienced gender. So who the person believes they are as in terms of who, their own gender identity, and assigned gender. So that's the outward presentation of the biological sex, lasting at least 6 months. This is the definition that is offered by the American Psychiatry Association. And so if this is what's happening, if the child is diagnosed with gender dysphoria, or the person is diagnosed with gender dysphoria, then they begin to consider what their treatment options are. But so why don't we just say over 18? Well, I just said some of this happens before they're 18. They need help before then, and those options need to be available to them. And by those options, I am talking about a range of treatments. And surgical treatment is way down the line from where they begin and takes and it happens over a number of years. I'd want to also say that there are a number of medical professional organizations that oppose adding the age 18 to the law. And they include the American Medical Association, the American Psychological Association, again, the American Academy of Pediatrics. These are the people that we take our children to and that we trust with their medical care. And the American Academy of Child and Adolescent Psychiatry. We need to start treating them as soon as it is diagnosed. Sometimes life-saving treatment. So that's, the background. But the most cogent reason for not putting this in the law is we as legislators should not be in the business of dictating medically necessary care for any individual. This is a decision, medical care and health care is a decision between an individual and their health care provider. By putting limits, any kind of limits in this bill, we are dictating what they can do. And it's not, if we don't want to impose ourselves into an individual case by case, let me say that again, case by case, each person has a different manifestation. If you've seen, somebody once said to me, if you've seen one case of breast cancer, you've seen one case of breast cancer, because it is an individual analysis, diagnosis, presentation. So we need to make sure that we are not trying to mandate and dictate what they can, what the patient, the parent, if they're under 18, and the provider can do in order to help these individuals be healthy. So I would, and children who are on Medicaid. So those are some of our poorest children. Some of their parents are making less than $20,000 a year. Try living on that in Maryland. And they're now being denied the important medical care, or could be denied the important medical care that they need if we were to limit this with this amendment. So I would ask the body to reject the amendment.
Madam Speaker.
Gentlelady from Hartford.
Thank you, Madam Speaker. I really appreciate the dialogue today. I appreciate both the chair and the vice chair and their candor, and I know many of us feel deeply about this issue, so I'm going to just share a few of my thoughts and why I think this amendment is so important. I agree with what the vice chair said on how these are the most vulnerable children. They're also the ones that are going to be the least likely to be able to protect themselves from bad medical treatments. And so it is our duty as a body to make sure that we are standing vigilantly to make sure that what they're getting is actually evidence-based care. To touch on a few of the points, the list that was read of all of the people who currently profiteer off of doing this to children, I think was a really good lesson in groupthink. But I would like to address specifically what other places around the world are doing, including many nations that we are very familiar with. So I'll just go ahead and read you a few of the updates to policies for some of these countries. Sweden, in 2022, they deemed that there was a continued lack of reliable scientific evidence concerning the efficacy and safety of both puberty-blocking treatments and other types of hormone treatments for minors. Britain, the UK, evidence on the appropriate management of children and young people with gender incongruence and dysphoria is inconclusive both nationally and internationally. That was also 2022. In fact, in the UK, there was litigation on this matter. There was a very popular gender transitioning clinic called Tavistock. This went through the high courts in England. All of the relevant evidence, scientific-based evidence, was brought forward, and they ended up shutting down not only Tavistock, but also banning the use of puberty blockers in children, because it causes detrimental long-term health effects, and the majority of children change their mind when they're given time to develop. Finland just recently banned it. The first-line treatment for gender dysphoria is psychological and social support, as necessary psychotherapy and treatment of possible comorbidities and psychiatric disorders. They completely oppose putting hormones into children whose brains are still developing. And the studies go on and on. I mean, I've got 20 studies here that talk about the risks to children and the lack of evidence, including studies that discuss no impact, no reduction in suicide attempts at any step in the process of cross-sex medical intervention. No reduction in suicide. In fact, a 2015 study found that being in the process of cross-sex medical treatment was associated with a 3-fold increase in suicide attempts. A 3-fold increase. That one is from 2015. So there is a lot of research that shows that the U.S. policy on this issue is going in the absolute wrong direction from the rest of the world. In 1888, the first lobotomy was performed. We failed to ban that, and it continued until 1967. The last person that got one died. Many, many lives could have been saved if we had stepped in as a body and said, this is bad science, it's not based on any evidence, and it's killing people for absolutely no reason. So it's incredibly important that we consider the damages that we're doing and that research is going the opposite direction in every other place except for apparently the few trade organizations who are literally making money off of it. Those are my main concerns, body. I am sure that you can share them with me, but I'll just finish with this quote from our own FDA on this issue, if I can find it in the stacks of research that I have here. Our FDA, quote, "These hormone puberty blockers have been FDA approved only for the treatment of precocious puberty, not gender dysphoria in pediatric patients. They are not approved for halting normally timed puberty, and they are considered experimental." We are allowing experimental gender treatment of children in our state already for those who are private paying. But we are about to allow the poorest among us, who are the least likely to be able to fight back against this, to do the exact same thing. So I am asking you, please, body, support this amendment, protect those children, because if they are 18 and they want to make these changes, it is one thing. But if they are under the age of 18 and their bodies are still developing, you are permanently altering what they are ever going to be capable of. And many, many of these children grow out of this. Many, many, the vast majority. So with that, Madam Speaker, I would support this amendment.
Madam
Floor
Speaker.
Leader.
So this didn't have to do quite as much with 18 as I thought it might, but I just wanted the opportunity to respond. Sweden continues to offer gender-affirming care and continues to offer it to adolescents. The United Kingdom continues to offer gender-affirming care. The litigation case that the good delegate told us about was overturned, and in fact, the center, the reason it closed, if you look at the reports from BBC, the reason the center closed is it was overutilized. They could not meet the need. So what the UK decided to do was to put gender-affirming care centers in different regions, so they made it more accessible. Finland continues to offer gender-affirming care. The study that I think the good delegate was referring to that said that there was no reduction in suicide prevention after being, or reduction in suicides after being given gender-affirming care. Well, the author himself said that you can't draw any conclusions from his study because he didn't study transgender people before and after gender-affirming care. He studied folks who had transitioned opposed to the general population. So it's not, you're comparing apples to apples, and you're not getting a fair number, and the author of the study said that. So back to 18, 98% of the adolescents who begin gender-affirming care prior to adolescence continue it throughout their life. And remember, there's a range of services, and not every person will choose all of the options available to them. They're going to choose the ones that the individual, believes are most effective for them to self-actualize in their own gender identity, with the support of a medical professional or many medical professionals. I do want to respond to the concern about that was raised about the puberty blockers, and the fact that the FDA said what they were branded for, what they were labeled for, but this is an off-label use of the puberty blockers, and is in off-label uses are determined within the context of the standards of practice. And I'm being told that 20% of medications given to children are off-label. I'm not talking just about puberty blockers, I'm talking about all medication. So and there's been a lot of study on whether or not these, they work for children, and we've determined puberty blockers have been used for almost 50 years. And they've been used safely and effectively. And for folks who are wondering here what happens if the child, and I go back to the good delegate who said, some change their mind, which is why the definitions say that the condition, the distress that the individual is experiencing has to last at least 6 months. And if they're in a gender-affirming care program, there will be a minimum of a year before they can go to the next level. So again, it is a long-term process. And puberty blockers are, contrary to some articles out there, are totally reversible. Once the individual stops taking them, their normal pituitary gland kicks in, and they go back to being the biological sex that they were assigned. So with that, Madam Speaker, ask the body to reject the amendment.
Madam Speaker.
Gentlelady from Hartford.
Thank you very much, Madam Speaker. So I have here a 2011 study, a 2014 study, a 2015, 17, another 2020, 2020 again, 2020 again, 2021, 22, 22, 22, 22. All of those studies say it does not decrease the risk of suicide. It is not one study, it is not one guy, it is many, many, many studies and many, many, many people. And I will just read for the body what the British National Institute of Health said in 2022. Evidence on the appropriate management of children and young people with gender incongruence and dysphoria is inconclusive both nationally and internationally. And I will just remind the body that in Finland, for example, they suggest psychotherapy and that no hormones should be given to children who are still maturing mentally. So this is not a one-off guy. This is not a one-off study. If any of you would like copies of these studies, I am happy to give them to you. You are welcome to reach out to my office, and I will share them with you. And finally, I will just talk for a moment on the subject of easy reversibility. The Royal Osteoporosis Society states quite clearly that you are at a significantly increased risk of osteoporosis if you are taking cross-sex hormones. Have hormones been used for many years? Of course they have. They're used for children with precocious puberty. That means children who enter puberty too early, and they're given these hormones to hold it for a little longer so that they can wait until their body catches up. It's not been given for 50 years to change someone's gender. And in fact, what used to happen with gender dysphoria is that they would give the child their own gender's hormones. That's what they used to do. So this is fairly new. I think the first ever case was 1983 that they tried, and it wasn't very popular even then. So in addition, I just want to say that there is a lot of research into the harm of puberty blockers, and I know another member has done a lot more research and is a medical professional and will probably be addressing that. But this is not a fringe thing. Many, many, many countries are going the opposite direction. France, Australia, New Zealand have all started prioritizing non-invasive treatments and psychotherapy over puberty blockers and other forms of damaging treatments for children because it is so hard to reverse them and it's not helping them. It's not changing their outcomes of suicide. So there really is no reason for us to allow our children to be experimented on. Thank you, Madam Speaker.
Gentlelady from Frederick.
Thank you, Madam Speaker. If the floor leader is not too tired, would she mind raising for questions? I can talk for a second before you have to answer. Okay. I appreciate it. So when I'm down here for these 90 days, and I'm very new at this, the one thing I never want to forget is that every law we pass impacts real people. It impacts our children and our friends and our neighbors, the people we go to church with, synagogue, the people we work with, our community. And so when I'm asking these questions, we are truly just trying to understand and make sure that we know exactly what we are voting on and what the impact will be. And that is what the spirit of these questions are about. And I'm going to try to keep it to the under 18 amendment, okay? So I was a little confused and again, it's about minors having certain procedures, and I'm not going to list them all again. When you said that a minor can't have these procedures, the part of the law where I see that it is the intent of the General Assembly that the program provide gender-affirming treatment to all program recipients for whom gender-affirming treatment is medically necessary, including transgender, non-binary, intersex, two-spirit, and other gender-diverse individuals. Is that where the age piece is listed in the law, or is there another place where the age piece is listed in the law?
There is no age in this law, because what we are doing is making sure that the options are available as deemed medically necessary. And oh, by the way, welcome, Delegate. We're so glad you're here. And
I know we haven't met yet. We officially talked a lot. I'm sad that we're doing it under this, but no, I really respect you.
That's our job.
Thank you. So at what age then, so if there's no ages in this, and we know that the program recipients are all ages, right, from birth up, right? At what age could you start gender-affirming care then? If it's not, because my colleague had the amendment for 18, which is what a lot of us believe.
So the standards of care for children begin with psychotherapy and socialization activities, because for the folks, the particularly young who find themselves in a situation where they're experiencing that extreme duress, because when they look in the mirror, they don't really see themselves. And that's a very hard concept for some of us to acknowledge, but it causes them great distress and anxiety. So when it's recognized early, the first interventions are psychotherapy, and that can go on for years. For other decisions are made more closely to adolescence, because, and again, I am going to say it again, it's the patient, it's the parent, it's the medical provider who are making decisions based on medically necessary and indicated. And I need to say really, because I have to, medically necessary means that if you don't do it, the risk to the individual goes up. So that's why it's, we want to make sure that the law specifically says medically necessary and indicated, because we want it to be absolutely, we want to avoid the issues of, that there might be a mistake made. Because we want to make sure that we're providing the right treatment. You may, in adolescence, you may decide to do the puberty blockers or hormones, and then as you age, during adolescence, you may make the only decision you would make about any kind of surgery would be, after lots and lots of discussion of options, gathering all the information, and it would only be done under 18 in very, very rare circumstances where the medical professionals and the parent believe that the child is in danger if they don't. So it's extremely rare, and I think I read the number that in the entire United States, only 300 young people have had gender-affirming surgery.
Okay.
Out of 300,000.
And then
so it's again, we want to take our time with this because we want it to be right.
Right, and I understand that, but as we've seen in rates, the rates are increasing as people who identify as transgender. So those rates may change, and allowing it by law or under 18 may cause some difficulties for people, and that's why my colleague brought the amendment. That's the spirit which he did that. So back to the law, how do you then define and measure clinically significant stress resulting from gender dysphoria? Because that is also written in law.
Okay, so we trust our providers to do that. I am not qualified in any way to make a decision about that. That would be the appropriate provider, the patient, the parent, the psychiatrist, psychologist, counselor. Those are the folks who are going to make that decision.
And I'm so glad to hear you keep mentioning parents. So since we just passed a law in 2021 that allows the 12-year-olds to consent for therapy as an adult without the notification or consent of a parent, and a 16-year-old can receive medications for mental health disorders, and I'm not sure as far as gender dysphoria, it has changed as far as the DSM and exactly where it's categorized. Where does counseling and treatment for gender dysphoria fit into this? Because I heard you say a lot of the 6 months thing. I think most parents are going to want to know, which also speaks to my amendment, would a parent be kept out of helping with these life-altering decisions?
The law currently requires that the parent is involved in any kind of gender-affirming treatment.
The new law? The one we're just passing, how it's written.
No, the current law, no children, with the exception of mental health, and the reason those bills passed is because we saw that students were asking for help. I mean, we had youngsters come to our committee and say, we need to be able to see someone, and sometimes, it's what's going on at home, and they feel unsafe but we know that if gender dysphoria becomes an issue, then there would be, they'd have to move up to inclusion of the parent.
Okay, so unequivocally.
Unless they were emancipated, I'm sorry.
Yeah, I understand. Yeah. Yes, definitely understand. So under no circumstances would a parent be excluded from these discussions other than if they are an emancipated minor up until the age of 18.
Correct.
They would be, a parent would have to sign off and be part of that decision.
Right.
I mean, that's huge, and that's very clear. Says there are studies that show that minors cannot truly give informed consent, and that their developing brains and minds that change often may have trouble fully grasping the long-term consequences and decisions. I do want to speak a little bit, and I know there was a lot of when we talked about puberty blockers, and is one of the most common the GnRH, which is the gonadotropin-releasing hormone. Is that one of the most common ones? I'm just speaking to it because this is coming from the Mayo Clinic as far as side effects. This isn't me. This isn't a study making up. This is research from the Mayo Clinic that said that use of GnRH analogs might also have long-term effects on growth spurts, bone growth and density, future fertility, which is huge, depending on when pubertal blockers are started, and then if children with male genitalia begin using these analogs early in puberty, they might not develop enough penile and scrotal skin for certain gender-affirming genital surgical procedures. So, I mean, this is not me. This is the Mayo Clinic. Anyone can look that up. So I just want to say there are other studies that are showing that. There are other places that are showing that there are issues with these puberty blockers that are medically reputable institutions.
Right. That, if I may, Delegate, that's why parents are involved in the conversation, and the medical providers are going to be able to mitigate some of the side effects. That's, and they can decide whether or not the risk is worth it for them. But I'm going to go back to the fact that those blockers have been used successfully for 50 years.
Right.
And we have studies that show they definitely support the student's development and mental health.
And I get that, and I don't know if they've been used for as long of time as we're talking about using these, especially if someone's waiting longer and longer until they're closer to 18 to have any kind of surgeries, like you said. So is there a medically agreed upon length of treatment of puberty blocking before switching over to cross hormone? And how long has someone been on puberty blockers and then they did resume the complete normal puberty that you talked about? Like, is there a length of time where that would be?
It is a totally individual case by case, and based on the symptoms of the patient, and also the discussions and information that the family has, and always with an eye to the standards of care.
As it should be.
Right.
Thank you.
Thank you very much.
Thank you very much.
Gentleman from Carroll.
Thank you, Madam Speaker. I just wanted to speak in support of this amendment. I just want to read something I think is important to hear, and it does apply to this amendment, particularly as it relates to children who could potentially receive this treatment. And I know it's been a long discussion, so I'm not going to read this entire article here. Just going to kind of skip around a few excerpts here. So this is an article that just came out it was published last month, and it was about a biological female who had transitioned to a male and then detransitioned, named Chloe Cole. She was put on puberty blockers and testosterone at age 13, and at age 15 she underwent a double mastectomy. And then at age 16, just a year later, she decided to detransition, and now she's about 18, and so here 2 years later, she's continuing to experience painful side effects from those medical interventions. She reported that the double mastectomy procedure caused fluid to leak. She said that she doesn't know if she'll be able to carry a child to term. And because of the testosterone, she's got permanent changes to her bone structure that cannot be reversed. She has issues with her urinary tract. And because of the mastectomy, she'll never be able to breastfeed. Furthermore, she talked a little bit about how she came to her decision to originally get this surgery and then decide to kind of come back. I said, at this point, I'm far from whole, I'm far from healed, I'm still processing and dealing with what I went through. I've lost all my trust in my healthcare provider and possibly even healthcare. She said she wasn't really allowed any time to just be observed alone without intervention. It was only about half a year in between being diagnosed with gender dysphoria and actually being medicated. So the process for her was very expedited, and there was not really any pushback from any medical professionals, she said. She began to question her identity at the age of 12, and her parents were advised by medical professionals that she would commit suicide if she was not affirmed with medical intervention. And Chloe said, my distraught parents wanted me alive, so they decided to listen to the doctors. And I'll just wrap up with this, because I know it's been long. She said, I've been emotionally and physically damaged and stunted by so-called medical professionals in my most important developmental period. I was butchered by an institution that we must trust more than anything else in our lives. It is not loving to lie to a child. It is not loving to disrupt a child's natural, healthy development or to encourage them to do so. And with that, I urge this body to support this amendment. Thank you.
Madam Speaker.
Maker of the amendment.
Thank you, Madam Speaker. I do want to thank you, Madam Speaker, and the committee chair and the floor leader for allowing this very important debate. I think that's important to say first. To finish, I just wanted to reread the amendment. The program may not provide gender-affirming care to recipients under the age of 18, including puberty blockers, for the treatment of gender dysphoria in order to provide gender confirmation care. That is the amendment. The science is not settled. Without question, the science is not settled. And as such, we do not experiment on children when the science is not settled. Thank you, Madam Speaker.
On the amendment, all in favor signify by saying aye. Oppose? Roll call.
Madam Speaker.
Is everyone out of the lounge?
Madam Speaker?
Yes.
I apologize, my button's not working. No,
And
I've been trying.
is it working now?
It's still not working, Madam Speaker. I've tried 3 times. Oh,
You
now
need
it's
to
working. Thank you.
Okay. Clerk will take the call. The amendment fails. Are there any? Gentlelady from Frederick.
Madam Speaker, I have an amendment at the desk. It is amendment number 613726-1.
Amendment number 1.
Move so much be considered the reading of the amendment.
So ordered.
Thank you, Madam Speaker. Colleagues, many of you may realize by now that I am an advocate for women, children, families, and parents, and I am passionate about education and health care. And this legislation does have an impact on families and on children. And there are going to be cases where not all parties agree on the best path forward. Now, in current law, these choices are made when you are 18 or older. Reasonable to conclude who makes the decision about their body then. However, the proposed changes and what our failed amendment tried to maintain was and eliminate that there will be an age, now there will be eliminated an age threshold, pushing these decisions down into the family dynamic. There are going to be disagreements, as you heard here, with the back and forth over what is in the best interest of that child's health, perhaps even between parents, as we have seen already. This amendment says that in cases where both parents do not agree or give consent for the minor to have gender-affirming care or treatment, or if only one of 2 parents agree that this is the best path forward, then a hearing will be held and an ad litem will be appointed to advocate for what is in the best interest of the child. These are life-altering, body-altering medications and treatment. And we do know now that there are adults on the journey to detransition from the choices they made when they are younger. And I want you to understand why some additional time may be needed to think of all possible outcomes. This chart is from the National Institute of Mental Health, revised in 2023, and it talks about the teen brain and 7 things that you should know. It's available for anyone. And one is that the part of the brain behind the forehead called the prefrontal cortex is one of the last parts to mature. The brain finishes developing and maturing in the mid to late 20s. And this area is the one responsible for skills like planning, prioritizing, and making good decisions. Brain development is also related to social experiences during adolescence. And changes to the areas of the brain responsible for social processes can lead teens to focus more on peer relationships and social experiences. and the emphasis on peer relationships along with the ongoing prefrontal cortex development might lead teens to take more risks because the social benefits outweigh the possible consequences of a decision. And these risks could be negative or dangerous, or they could be positive. So this, like I said, this is from the National Institute of Mental Health. There are reasons that parents should be involved in this situation. But like I said, not all parents, they're not going to agree. And sometimes they may disagree with the minor child. And we do have laws on the books that I am worried that would allow for children. And I so appreciate the floor leaders clearing that up for me, because it was definitely one of my concerns. And of course, I wrote this amendment before we had our discussion, which is why it's so important. So, gender affirming treatment may include, there's a may statement. The only last question I have about it, I'm not going to belabor this, because I do think that that sometimes we have to have a vote of conscience and not a vote along party lines. And we are trying to put some common sense age limits on to these very difficult decisions. And like I said, making sure that parents are involved. And I just had a little question about WPATH, but I mean, we can let that go, but it is in the legislation, and maybe at some point we can have a discussion offline about that, on what the impact of actually putting that into law would mean. But as of this point, I'll go ahead and move the amendment, Madam Speaker.
On the amendment, floor leader.
Thank you, Madam Speaker. And I really want to thank the good delegate for giving me the amendment in advance. So we've sort of gone through the 18 part of it. But in terms of adding a hearing to go through when the parents disagree, I would suggest that that law already exists on the books. And in the Health General article, I think it's section 102, it clearly defines when the parent and the child are in disagreement around what kind of treatment they want, then they, it's defined, the process there is defined in terms of, how to deal with that. I think you sort of tangentially mentioned when two parents might disagree. And how do you resolve that? And that's resolved in law as well. It's in the family law issue and in statute, and it depends on the condition of the conditions of the separation or divorce agreement. So medical decisions medical decision making defaults to whichever parent is granted is designated in the agreement. So for 50-50. Most agreements have a mediation clause for these kinds of issues. So for that reason, we also, these young people are already in great distress. I mean, I can't even begin to imagine the level of distress that they are in. And so adding court hearings might just add to that. So for those reasons, I'd ask the body to resist this amendment.
Madam Speaker.
Thank you, Madam Speaker.
Minority.
I appreciate the perspective of my friend from Montgomery County about this, but I can tell you this. I'm not a divorce lawyer, but I know many, many horror stories. She's absolutely correct that in most divorce and separation agreements, when you have minor children, there's some provision as to who has what we formerly called legal custody versus physical custody and who makes medical decisions. But the concept that if the two parents can't agree as to something so significant, so life-altering as this particular set of procedures, this is something that very literally changes the scope of your life, and with the exception of potentially the puberty blockers, the surgeries themselves may become, in fact, irreversible. The decision to allow that to happen and assume that the two parties, the mother and the father, or however you want to look at it, the two parents, they may go to a mediation and they'll resolve it. There are things sometimes that mediators cannot resolve. There are two people who have extremely different perspectives and different thoughts about what's in the best interest of their child. And the way our system works is when that happens, you punt. It's a terrible thing. You punt and default your decision-making ability as a parent
which all of us that have been parents feel is very, very central to that relationship, you punt it to a third party, to a judge, to a family law magistrate, and that individual makes that decision. And what the gentlelady from Frederick's amendment essentially does is when this happens and the two parties, the two parents say, hey, we cannot come to agreement about something that will forever alter our child's life, and we have a serious good faith disagreement about what is in that child's best interests, the court can appoint a guardian ad litem, and that's essentially an attorney, who can then advise the court through a court proceeding as to what is in, and here's the key phrase, the child's best interests. Shouldn't that be what all of us care about? I understand children are in distress, we got to make a decision. I would hope that we're not saying my child's in distress and they want to have these incredibly significant surgeries that I'm not even going to talk about because I'm not sure I really technically even understand all of them. I would hope that we would say they're in such distress that we can't wait a month. We can't wait 2 months. We can't wait 3 months and have an emergency surgery. I would hope that if these individuals are in such psychological distress about this gender dysphoria diagnosis, that they are under frequent and constant counseling and help and assistance. I would hope that those around them, the parents who love them, and they must love them enough to want to participate in the process that this amendment would establish, I would hope that those parents are in constant and frequent communication from a perspective of kindness and love with their own children. If I know you're going through something, maybe I don't understand it, I'm not telling you you're wrong or you're right, I'm just telling you hold on. Puberty is hard, man. Teenage life is hard. We all laugh about it thinking back, but imagine yourself at 15, 16, 17. There were things that probably really, really upset you. You didn't get asked out by the boy or the girl that you wanted to. Your friend that was your best friend in middle school was in a different clique now. You didn't do too well on the test. You didn't make the team. Those things that we as adults sit there and we're like, yeah, you know, life isn't easy. You shrug it off, you move on. Puberty is hard. And suggesting that somehow we can't slow the process down a little bit when we have two parents who want to slow the process down, not to make their children feel worse, but to give an equal opportunity because they can't make the decision. They have to punt that to a third party to decide the child's best interests. That's all the amendment does. I think it's very reasonable, and I hope that it's viewed in that light. Thank you, Madam Speaker.
Floor Leader, Vice Chair.
Thank you, Madam Speaker. So I would suggest that it would be discriminatory to carve out this kind of health care from our current family law. It is health care law, and finding the right health care for your children, or our children, is already covered in our law, and to separate this law out would be significant. The process gives you time. Puberty blockers gives you time to make those decisions, because if the child is on puberty blockers, you've got time before any more serious kinds of, gender affirming care happens, for the parents to come together and resolve the issue. So I would respectfully ask that the body resist this amendment. Thank you.
On the amendment, all in favor signify by saying aye. Aye. Oppose? Roll call.
Madam Speaker?
To explain my vote, Madam Speaker.
Generally from Hartford to explain her vote.
Thank you so much. Body, there is a woman in Maryland right now. She has two beautiful children. She, 2 years ago, got out of a narcissistic, abusive relationship with her spouse. She escaped. Not many do, but she did. And right now, her young teenage child is being put on puberty blockers without her consent. We are passing a bill, we just passed a bill through Judiciary that allows for people who have family members that are a spouse that is, or an ex-spouse that's living outside the country or has citizenship outside the country, for them to have emergency access to the court systems. So we are separating out people with an immigrant parent to have special access to the court system in an emergency basis to prevent someone from violating an existing parenting contract. This amendment only offers the same protections for a spouse who's worried about their child going internationally with their ex, for children whose one parent has put them on puberty blockers. I think many of us who have gone through the court system on family law understand it can take months to get a hearing. That was the justification for the other bill that you'll be voting on very soon here. And this offered amendment does only what we're doing for those families, for the families that are dealing with one parent who is making medical decisions like this that can be life-altering for their children.
Okay. Clerk will call the roll. The amendment fails. There are any additional amendments to the bill as to its title? Hearing none, the bill is ordered printed for third reader. Quorum call.
Madam Speaker.
Everyone out of the lounge? Clerk will take the call. There being 136 members present, the House is still in session. Calendar of third reading House bills number 43. Clerk will read the first bill.
House Bill 200, Budget Bill, Fiscal Year 2024.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker. Just briefly.
Oh, sorry.
That's all right. We've talked about the budget a lot. I'm not going to belabor it because I know we have had a lot of discussion. But I do think we have a good budget in front of us. As the minority leader said yesterday, I think it reflects a lot of our shared values. Just briefly on a couple of points that we have not discussed yet. 2 years ago, the voters of the state of Maryland gave us the authority to add to the budget. That authority was delayed for 2 years until our next governor came in because it wasn't a partisan authority. It was about balance of power. We could have used that balance of power in a number of ways as a legislature and as a body. We could have chopped up the budget, used it on a bunch of personal priorities, right? We could have done like other states do and have our own House budget. Could have done that. I don't think that that would have been prudent or reflective of the responsibility that we have as a legislature to be a partner with the executive. We also could have just acted like status quo, like there was no change. Again, I don't think that that also would have reflected our independence as a legislature and our partnership with any administration. What we did is we judiciously, I think, went through this budget and added what were really House priorities. And I think that not just the committee can be commended for that, but I think the entire chamber. We saw amendments yesterday from the minority party, which I think reflected that. I didn't agree with them, but I think they were strongly held values and beliefs of the minority party. They weren't a bunch of pet projects. They were things that were important to the minority party. So I think you can be proud of the things that we added to this budget as a legislature, things like investing in capital projects all across the state, money to implement the state's Alzheimer's program, increased funding for rape crisis centers, and probably the most important, $400 million as an additional down payment for the Blueprint for Maryland's Future. You know, the Blueprint includes concentration of poverty grants, community schools now in 22 of 24 jurisdictions, pre-K program. We talk about ending child poverty. The Blueprint has wraparound services for behavioral health and other community assets. One of the best things we can do to end child poverty is do a down payment on our Blueprint. And so I think for generations and generations, when times got tough, these populations that we've talked about have had their back turned on them. I think this legislature can be proud that the commitments we've already made, the commitments that this legislature and this state has made to its children all across this state are being recognized, that we are going to stand by them. I think, Madam Speaker, both procedurally and substantively, this is a budget that we can be proud of. I urge a green vote on the budget. Thank you.
Question for the House, unless there's any debate. Is House Bill 200 is on third reading and final passage. Is there any further debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 130 votes in the affirmative, House Bill 200, having received a constitutional majority, is declared passed. Clerk, read next bill.
House Bill 202, Budget Reconciliation and Financing Act of 2023.
Committee chair going to say anything? You good on that one? Huh? Only get up once? Okay. Gentlelady from Prince George's.
I just wanted to verify that my vote was green on 200. I'll check, Madam Chair, but Madam Speaker.
Okay. House Bill 202 is on third reading and final passage.
Madam Speaker.
Gentlelady from Baltimore County.
Thank you. Will the floor leader rise, please?
Floor leader.
Good afternoon. Thank you. I'm reading the fiscal note, and I don't know because I'm sure that the BRF has been amended, but on page 3, it said it reduces the fiscal 2024 funding that the governor must provide to the revenue stabilization account, which is the rainy day fund, by $1 billion.
The budget left with the full 10% rainy day fund. This was a swap, if you will, that just needed to be done in the BRF. 10% rainy day fund, which is the same as we did last year with Governor Hogan's budget, and is probably 5% more than what you've seen really in previous years, where we had traditionally a 5% rainy day fund. So it's kind of just a swap there to make sure that the rainy day fund ends up at 10%.
So the fiscal note's not right, or you didn't put in the full amount?
The fiscal note is right, and we put in the full amount.
The fiscal note's right that $1 billion less was put in, but it was the full amount that was...
It was accounted for elsewhere, so it's just a swap.
In a savings account or a spending account?
In the fund.
I mean, the rainy day fund's a savings account, right?
It's in the rainy day fund, 10% rainy day fund.
So how much do we have in the rainy day fund?
10%.
Okay, which is?
2.125 billion, $2.5 billion.
Wasn't there more than that? Is this where, if I'm remembering the budget highlights, we don't have as much in as we had last year?
No, we did 10% last year as well.
But was the total amount more than $2 billion?
It probably roughly the same amount. Yeah, it's a little more than last year.
All right, I'll take a look at it. Thank you for answering my question.
Thank you. Sorry.
Is there any further debate? If not, clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change your vote? If not, the clerk will take the call. There being 111 votes in the affirmative, House Bill 202, having received a constitutional majority, is declared passed.
Madam Speaker. Thank
Yes,
you.
Gentleman from Prince George's.
Thank you, ma'am. I would like to, my button did not work, and if we could please ensure that for HB 200, if I could be recorded as an aye. In green. Thank you.
Okay, special order calendar number 34. Clerk will read the bill.
House Bill 135, Controlled Dangerous Substances, Volume Dealers and Drug Kingpins, Cannabis. Favor report is amended and adopted.
Recognizing the minority leader who made the
Thank you, Madam
asked for a
Speaker.
special order. Rather, sorry.
I have an amendment at the desk. I'll go ahead and read that first, and then maybe the floor leader could indulge me. It's Amendment 793823/1.
Amendment number 1.
Move so much be considered the reading of the amendment.
So ordered.
Thank you, Madam Speaker. Would my friend from Montgomery County, who I understand is the floor leader, I want to make sure this is if you would indulge me a question or two before we discuss the merits of the amendment. I just want to make sure that I'm getting this right. It was a bill that was fairly significantly amended. It touches on quite a few different aspects of criminal law. The fiscal note says that under the bill, we're changing the penalties for both classifications called volume dealer and drug kingpin. Is that still the case after the committee's work on the bill?
Yes. The bill as introduced was attempting, in light of legalization, to make adjustments to cannabis penalties. In particular, it flagged that even after legalization, we had mandatory minimums of up to 20 years for high volumes of cannabis. And so that was the bill as introduced. We did take an amendment in committee that is actually quite significant. So I'm not sure if you want me to
So is that
for
the drug kingpin section, where the bill originally said a drug kingpin whose drug kingpin status was determined by cannabis, the bill originally said would be subjected to a 10-year maximum sentence, and now you amended it to 20?
So the bill is introduced. There was two laws that were originally seeking change. One was volume dealer of cannabis, and the other was a kingpin of cannabis. They came with a 5-year mandatory minimum and a 20-year mandatory minimum, respectively, both felonies. After the amendment, it would become a 10-year misdemeanor on a high-volume, maximum 10-year misdemeanor on a high-volume cannabis dealer, and on the kingpin, that would go from a 20-year mandatory minimum to a maximum 20-year felony.
Okay. So I'll try to focus on the volume dealer. The fiscal note said a person who violates the volume dealer statute of the criminal law article by manufacturing, distributing, dispensing, or possessing 50 pounds or more. I'm not sure a lot of people really understand what the requirement is to be this level of dealer. It's 50 pounds or more of the illegal substance. Is guilty of a misdemeanor under the volume dealer, and on conviction will be subject to a maximum sentence, of 5 years and a $50,000 fine. Have you now changed that to say that that's a minimum of 5 years?
No, maximum of 10.
Maximum of 10. Okay. And so would it be fair for me to say then, and then I'll address what my amendment does, that those two aspects of the bill reduce penalties on people who are illegally dealing cannabis? They're not legal. They didn't get a license. They're not operating a dispensary. They are the illegal so-called black market of cannabis, and they are people who are possessing 50 pounds or more and still distributing and selling it outside of our scheme.
It's not entirely clear that it's a penalty reduction, because on the volume dealer offense, it's going from a 5-year mandatory to a 10-year max. The original purpose of this bill was to say that mandatory minimum sentences, and we have to be very clear about this, we are talking about putting someone for 20 years in a cage for selling, granted, high volumes of something that we have now made legal. And so taking that mandatory prison time, which would also then prohibit the judge from looking at any other factors regarding that individual, that was the original purpose of the bill, and that's primarily what the reform will do.
And I appreciate that. So your perspective would be, because it's not a mandatory minimum, the maximum has gone up, so that's now in the judge's discretion. The judge may give that person a year, which would be a reduction of the prior sentence. They may give them 9 years, and that would be different than the 5-year mandatory minimum.
Correct.
I appreciate that. Thank you. And I'll briefly, I don't mean to unnecessarily engage, briefly discuss what the amendment does some other things, and the bill does some other things. I'd like to start off, number one, by saying that the bill has some very good components to it, and as the committee amendment. And one of those is it removes, as I think the delegate from Montgomery County discussed when he talked about the amendments, it removes the unnecessary and unfortunately sometimes racial disparity with respect to sentencing and sentences served between crack cocaine and powder cocaine. That was a function of, we measure things by weight, and the weight of one thing weighs up more than the other, and they're both really the same thing. And we removed that both federally and at the state level for those penalties several years ago. I want to make very clear That's not part of my amendment. That is 100%, I think, the right policy to have, and that is involved. The bill also discusses and addresses some elements of guns. It really is about pot, crack, and guns. I'm not kidding. That's what the bill is. We could call it the Pot, Crack, and Guns Act. I don't know if people would appreciate that, but that's kind of what it does. And so within the bill structure, and what my amendment attempts to do is it removes the committee amendments and the things that change the penalty system that have been discussed for volume dealers and drug kingpins of cannabis. And here's why. You're right that cannabis has been made legal for simple possession, and you're right that cannabis is made legal for a licensed, authorized dispensary, grower, processor to sell. But it has not been made legal for drug gangs to sell it on the black market. And as my friend, the committee chair of the Economic Matters Committee that worked so hard on a licensing scheme for cannabis suggested, one of his primary goals was to eliminate using this as a black market product. It was to eliminate, because sometimes violence comes with that, sometimes other crimes come with it. It is not somebody, 50 pounds of marijuana is quite a bit of marijuana. It's not your friend in the dorm room in college that's selling a little bit of marijuana on the weekends at the fraternity or sorority party. It is a drug dealer. And it is a drug dealer who has said to himself or herself, I couldn't care less about Maryland making this legal. I'm not getting a dispensary license. I'm not getting a grower license. I'm not rehabilitating myself and going out into the field. I'm just buying from the same people that I bought from, and statistics consistently suggest in all studies that law enforcement does, vast majority of marijuana was coming into our country from illegal operations, frequently across the southern border. I'm still buying from those individuals, gang affiliated, and I'm still selling, and I may be gang affiliated. Period. And what I think what we're doing, and this is one part of the amendment, I apologize, it's a complicated bill and complicated issues. What part of that amendment does is to discourage and continue to discourage the black market, the illegal sale of marijuana, the drug gangs who will say, great, you legalized it, but not to my customers. I'm selling for $10 less a unit than what the guy is down the street. I'm selling for $50 less a unit for what it is when you can go in to your legalized dispensary. And guess what? Just buy from me, my man, because you're never going to get arrested anyway. You're not going to get arrested. You're going to have the marijuana. No one's going to roll up on you and say, where'd you get that? Did you get that at Joe's legal dispensary, or did you get that at Jim's illegal back room? Well, I got it at Jim's, but you can't tell the difference. And that guy, that person, that entity is going to say forever, I'm not getting out of the illegal marijuana business. They've reduced the penalties down. They've made it easier for me. My customers are no longer going to get arrested and roll over on me and say, oh yeah, I'm arrested for possession. Now how I'm going to get myself out of this, I'm going to tell you that I bought it from Jim, the illegal guy. I'm not worried. I don't have any problem anymore. It's legal. And the purpose of that amendment and the purpose of this reason, I understand the intent of, gee, it's a legal product now, but it's really not a legal product to sell it as an illegal drug dealer at volume and be a drug kingpin. Alcohol is a legal product. I cannot go out and just make beer commercially and sell beer across the United States. I can't be like, hey, don't go buy that Miller Lite at the legal bar. Buy Buckle Light because I made it and I sell it for $1 a pop less. Come to me. That's illegal. That's a crime. It's a federal crime, actually. And so it's the same argument, and that's what the intent of the amendment does. Let's not reduce these penalties, not just for normal people who want to join in this new regulatory regime with respect to cannabis, but for drug kingpins and volume dealers who are admittedly criminals and who are intentionally avoiding the legalized market that's been set up by this legislature. The other elements of the bill essentially are this. The bill does some complicated things with respect to guns. It does some good things. It adds some language expressly indicating a felony for the possession, the distribution, the transfer of an illegal stolen handgun. So we have a statute in Maryland that talks about the possession and the transport of stolen goods. So maybe I'm not the guy who stole it, but I knew or had reason to believe it was stolen, the product, and I kept selling it out there. So I'm part of the problem. I'm part of the overall conspiracy, if you want, of stealing things and then selling them. What our amendment does is it adds in very clear and descriptive language. It doesn't change any of the committee's good language that clarifies that those things are a felony. Illegal handguns, stolen handguns are killing people in our state every week. In our state, not just one place, in our state. They are illegal. They are stolen. And what we would like to do and what our amendment does is it makes the theft of a handgun a felony. Many of you that have been here before have heard why this is not the case, because years ago we changed our theft statute and said it's only a felony if the value of the good is now up to, I believe, $1,000. There are some handguns that probably qualify for that you can go in and do a certification from the owner or the dealer or whoever it was stolen from. This has a real market value of above $1,000. So if you catch the person who stole it, they're subject to a felony theft charge. But there are many, 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 many handguns, particularly used handguns, older handguns, that will never meet that $1,000 standard. And as a result, the prosecutors cannot charge that individual with theft of a handgun for a felony amount, for a felony charge. The amendment adds that back in. And to be fair and to be clear, to summarize the amendment as well, one of the things that the committee did in its amendments was, in fact, and I find it a little bit ironic, because we don't want to make the theft of a legal handgun a felony. We don't want to classify it as a felony. But we are now classifying the possession of a ghost gun, which we made illegal, a felony. What is good for the goose is good for the gander. I cannot understand the logic that suggests that if it's important to us to make the possession of a quote-unquote ghost gun a felony, but the theft of a non-ghost gun, of a gun that has a serial number on it and was made by Smith & Wesson, that's not a felony. And so we remove that section of the law, and I tell you why. No one wants ghost guns as used by criminals. We do not want criminals and criminal gangs to build their own guns from a kit in the basement and go out and use them to shoot people. But we also understand, and we talked about this last year in the debate on ghost guns, I think it was last year, the time runs together. We had a debate and a discussion about there are some people who would be innocently caught up in the new ghost gun statute. There would be some people who were gun hobbyists who had constructed a gun not to use criminally, never been used criminally. They may have a completely clean record, no intention whatsoever to use it illegally. And simply because they have its possession, they would be violating the law. And now the committee says, you're committing a felony, but if we catch you stealing a handgun, we can't charge you with the felony. The amendment corrects those ironies. We think that the amendment is a strong message that we are still tough on criminals who are drug kingpins and volume dealers, even of cannabis. Even of cannabis. If you're outside of the law by this wide extent, you're outside of the law. It is very, very strong message to send to those of you and to any of our communities that are plagued by stolen handguns being the source of so many of the shootings and the violence that occurs. It gives another tool in a prosecutor's toolbox to pursue those individuals who are involved in the theft of that handgun. And it normalizes and brings things into logical order as to how we penalize and how we characterize various crimes. Thank you, Madam Speaker. I'm sure subject to amendment or subject to debate, we'd move the amendment. Thank you.
Recognizing Vice Chair of the committee.
Thank you, Madam Speaker. It won't surprise you that I'm going to ask you to reject all amendments, including this one, to this bill. And let me just start very briefly on the amendment, and then I think I owe you an explanation of what we did to the bill. But first on the amendment, look, and I want to appreciate the minority leader both for sharing the amendment in advance, along with a little summary cheat sheet that explains what the amendment is attempting to do. And I actually think it shows that they put some thought into this and came up with things that are reasonable to debate. But again, I really do think the committee did a lot of work on many of these issues over the course of this session over a range of bills. And what you're seeing here is basically an omnibus bill now that tries to bring together a digestion of what we heard this session and from what our communities, our constituents, and what the stakeholders would like to see in updating the criminal code in Maryland. Now, this amendment, it has two problematic things, and the first one I'll flag for you is it proposes 40 years as a possible prison term for cannabis offenses in the post-legalization world. And I just want that to sit with you. 40 years in a cage for, granted, high volumes of something that is now legal. In every other state that has legalized, you do have a transition period where you're going to have people who legally purchase cannabis, perhaps in our state at a dispensary that we license. And they're going to go to a corner of the state where there aren't dispensaries, and they're going to resell that cannabis. And this 50 pounds that tags you a volume dealer, it's 50 pounds over 90 days. And it could be a 50-pound operation with 3 people over 90 days. Illegal. If this bill passes, that is still going to put you in jail for between 10 and 20 years max. But again, mandatory prison terms, and 40 years is an outrageous sentence in the post-legalization world. And you all saw the ballot results. I think we had one odd county where it was close, but every other county passed this in overwhelming numbers, and it's time for us to listen. So, 40 years in a cage, what does that stack up to? Murder, attempted murder, premeditated in this state, 30 years. Forced rape, 20 years. You're asking for a double sentence, again, for a cannabis violation. I don't think that's appropriate here. The amendment is also asking for a downgrade for ghost guns. Okay, I just want this to be clear. If you vote for this amendment, you are voting to downgrade ghost guns to a misdemeanor. So again, let me go back. This is now an omnibus bill, and I want to give you the explanation of what the bill does with the amendments, and therefore why you should reject this amendment. So as introduced, I said this bill was just about repealing 2 mandatory minimums. We did take a broader look, because when law enforcement came in on this bill, they opposed it heavily originally. And they said, we have a continued presence of guns being found in the illegal gun trade, and we're worried that what you're trying to do is going to impact this. So we said, all right, we're going to take a broader look at the issue of guns and the drug trade and try and handle this in a more broad fashion. So we added a number of things. Here's what the bill now does. It does repeal 2 mandatory minimums. As mentioned, it's going to maintain a maximum penalty of 10 years on a high-volume cannabis dealer and up to 20 on a cannabis kingpin. The first becomes a misdemeanor. The second remains a felony. The bill did not give anyone a way out of prison who was trapped with the old sentence. So we created a resentencing provision where those people can come in and ask for a modification. Only if it's in the interest of public safety can they be released. And to make this policy more consistent, we fixed in 2016 the crack cocaine disparity in Maryland, where you got a mandatory minimum for 8 times lower amount of crack than you did for cocaine. We fixed it, but those who were trapped on a mandatory minimum sentence, again, 20 years under that old sentence, we left them to rot in prison. And so we brought those folks in and gave them a one-time opportunity for a resentencing in this bill. And I'm glad that the minority leader concedes that that is the right thing to do for that very limited number of folks. What else did we do? So we brought in 3 gun crimes. We are creating 3 new firearms felonies in Maryland. And again, this is based on the range of bills we heard. We had some that were trying to make felonies out of, and increase penalties on fairly ordinary ones. We took a scan through the code and found 3 that jumped out as more serious offenses in this day and age. And I really think, to the minority leader's amendment, we actually covered this issue of the stolen guns pretty well. So the bill would make a felony out of possessing, selling, transferring or otherwise disposing of a stolen gun. We didn't include the bit about stealing it because if someone robs a car or a house, they turn up a bunch of items and the gun, it gives them the opportunity to say, oh my God, there's a gun among these things, I don't want to have anything to do with this. But if they retain it or they try and flip it, that's a felony. Possession of a stolen gun would be a felony. The other provision is ghost guns. That would also become a felony. The third firearms offense we brought in is manufacturing or trying to sell a firearm where you've deleted the serial number. That's a fine-only offense in Maryland at the moment, and we made it the same. So if you're trying to sell one of these sketchy guns, it's a ghost gun, it has a deleted serial number, or it's stolen, these are all now 5-year felony offenses in Maryland. It is not a penalty increase. It's already 5 years, but it's a misdemeanor. And what does that felony status come with? It comes with more time to investigate the crime on the statute of limitations. These cases are going to go to circuit court where more time and attention is spent on them. And these people, when convicted of these offenses, are going to lose their rights not just to wear or carry a handgun, but also to possess long guns. We also, in a separate bill, put most of these firearm offenses and a number of others to be investigated using the January 6th style facial recognition technology you've all seen in the news. So we really are taking a comprehensive approach to this issue. The third aspect back to the cannabis topic that we included in this bill was a request from a bill from a Republican lawmaker to clarify that the criminal prohibition in the cannabis bill that was passed previously about manufacturing products does not apply to ordinary things like people who are going to be manufacturing brownies at their home for non-commercial purposes. So that's the bill. Those amendments were adopted by this committee, bipartisan. I will concede that the vote on the overall bill was, however, partisan. But as I've explained to you, this is a very balanced bill. It's really taken time to cover a lot of the topics that you guys brought to us this year. This is it. And a majority of this committee has approved the bill with this mix of ingredients as the correct response to updating how we handle drugs and guns in Maryland in the year 2023. So I respect the work that the minority leader put into this. I appreciate the conversation. I'm sure it's going to continue for years, but I ask you to stand by the committee and reject the amendment.
Minority Leader.
Thank you, Madam Speaker. We definitely won't continue for years today. I know everybody's hungry. We'll continue for a minute or two. I do appreciate the recognition that I think the committee has made in listening to law enforcement officers. And something you said struck with me. Guns are intimately involved in the drug trade. Guns are intimately involved with the drug trade. So I hope we think about this not just on the amendment, on the bill, but everything we do here when we go, drugs, don't be too tough on drugs. It's not about the addict. It's about the seller. And what the seller uses to affect their market is violence or the threat of violence to protect themselves from other potential sellers or to enforce their bargains and their agreements because they can't hire the good delegate from Charles County or I to go to court and sue each other over who had an agreement to sell marijuana 50 pounds or more, X, Y, or Z. They use a gun to enforce those rules. And so I think that it is important to note, I respect what my friend said, we're not downgrading what the ghost gun statute is currently. It currently, as written, is a misdemeanor. The committee amendment now brings that and calls it a felony. And I would suggest that because of the concerns about wrapping up the handful of innocent people who may have something characterized as a ghost gun that was not using that quote-unquote ghost gun in any illegal way whatsoever, and now to characterize them as a felon is a significant issue. The other thing that I would say with respect to why we don't include theft of the gun. So what my friend from Montgomery County says is, I go in, I'm a criminal, not a good guy. I'm a criminal, I break into someone's house or break into someone's car, and I get X, Y, and Z happens to be a gun, and I take it with me, and I go, well, I'll just dump it, because that way if they find I don't have possession of it, I can't be charged with it. Where do you dump it? I'll be bluntly honest with you. In Allegheny County, Maryland, within the last year, a 9-year-old near a middle school campus found a loaded handgun left on a playground that was a result of a theft. Someone had broken into someone else's house nearby, had stolen some things, and whether intentionally or unintentionally, had left a loaded handgun that a 9-year-old picked up while playing with her family at a playground. That happened where I live. That's a significant issue. And the theft, there's no reason that you can't just add the words, theft of the handgun is also a felony. Just add it. Just add it. The reason why we can't do it seems to be, it's intractable. Because we decided years ago we couldn't for reasons that don't matter. We never will, because now it looks like we were wrong, or we should have done that before. And that's not a valid reason for doing that. And I finally would say this. You talked about these tremendous penalties, the significance of penalties for volume dealers and drug kingpins of cannabis. And you said, well, it's more than you would get for potential murder or for aggravated rape. And I would suggest to you that the problem therein lies not with the sentence for being a drug kingpin. The problem lies with too low of a sentence for being a murderer and being a rapist. I'm sure I'll know how this goes, but we would move the amendment, Madam Speaker, and I appreciate my friend and I appreciate our conversations, and he knows the good faith and the efforts that we tried to make to address these issues. Move the amendment. Thank you, Madam Speaker.
On the amendment, all in favor signify by saying aye. Oppose? Roll call.
Madam Speaker.
Clerk will take the call. The amendment fails. Are there any additional amendments to the bill as to its title? Hearing none, the bill is ordered printed for third reading. Message from the Senate. Consent calendar number 17. Senate bills introduced in the House. The clerk will read the first bill and committee assignment.
Senate Bill 31, Senator Carter, Ways and Means.
Recognizing the Majority Leader.
Thank you, Madam Speaker. So much to be considered the reading of SB 31, to be considered the reading of all the bills in the calendar.
Hearing no objections, the bills are read the first time and referred to the appropriate committees. Introduction of House bills during the last 35 days of session. You're going to have to tell us why it is late. Recognizing the committee chair.
Madam Speaker, I believe Mr. Baker is enjoying this too much. Madam Speaker, apparently it's my governor's fault. This is an administration. The administration provided this bill a little bit late, and so I'd ask the body please to support the bill. Thank you.
Shall the bill be introduced? It requires 95 votes. The clerk will call the roll.
Madam Speaker.
Clerk will call the roll. There being 135 votes in affirmative, the bill will be introduced. The clerk will read the bill in the committee assignment.
House Bill 1300, Chair, Judiciary Committee, House Rules.
Madam Speaker, can I just bring it?
Yeah.
Could I make a motion to refer to the bill to the Judiciary Committee, please?
Yes. I guess so.
Thank
yeah.
you.
All right.
I would like.
Wait a minute, hold on a second.
One moment, please.
Recognizing the sponsor.
Thank you, Madam Speaker. I'd move to have this, to suspend the rules and have this bill sent to the Judiciary Committee for consideration.
The question for the House is to refer HB 1300 to the Judiciary Committee. Clerk will call the roll.
Madam Speaker?
That's better. The clerk will take the call. The bill will be going to the appropriate committee with unanimous votes. Okay. Are there any additional? Nothing. Okay. All right. Clerk, I'm sorry. Clerk, take the call. I already said that. All righty. Okay. Could leaders come forward, please, up to the dais? That ends the work at the desk. Committee announcements, appropriations.
Thank you, Madam Speaker. The full Appropriations Committee will vote in the committee room at 2:30.
Judiciary.
Thank you, Madam Speaker. Gentlemen of the House Judiciary Committee will have a voting session at 2:45. 2:45.
Environment and Transportation.
Thank you, Madam Speaker. The Environment and Transportation Committee will have a public hearing immediately after this floor session for one bill, and then a voting session immediately after that.
Ways and Means.
Thank you, Madam Speaker. The Ways and Means Committee will not be meeting. Please don't have too many libations.
Economic Matters.
Thank you, Madam Speaker. The House Economic Matters Committee will meeting for a brief voting session immediately after session. Again, immediately after session. Thank you.
Health and Government Operations.
Thank you, Madam Speaker. The Health and Government Operations Committee will meet for a voting session at 2:30. Thank you.
Any subcommittee announcements? Yes.
Thank you, Madam Speaker. Natural Resources will meet at 3 p.m. on Zoom. Thank you.
Okay. Health Occupations.
Health Occupations will meet immediately after session by Zoom.
Land use.
Yeah.
Thank you,
Land
Madam-
Use and Ethics.
Thank you, Madam Speaker. The Land Use and Ethics Subcommittee will meet immediately after the ENT voting session today.
Motor Vehicles.
Thank you, Madam Speaker. Motor Vehicles will meet immediately after Land Use on Zoom.
Insurance and Pharmaceuticals.
Thank you, Madam Speaker. Insurance and Pharmaceuticals will meet immediately after Health Occupations and Long-Term Care. Okay. So it's about, it'll probably be around close to 2.
Real Property.
Thank you, Madam Speaker. Real Property will meet immediately after Land Use and Ethics and immediately after Motor Vehicles, whenever that is. Thank you, Madam Speaker.
Any delegation announcements? Got silent here. All right. Any caucus announcements? Oh, okay. We are coming back at 3:30, right? 3:30. Majority Whip.
Thank you, Madam Speaker. Colleagues, they are going to lock the chamber, so you can leave your devices here if you so choose. Thank you.
Okay. Delegates from Baltimore County, introduce the doctor today.
Thank you, Madam Speaker. Permission to use delegates' names?
Permission granted.
Thank you. On behalf of Delegates Cardin and Pasteur, please join me in welcoming today's Doctor of the Day, Dr. Lawrence Moss. His specialty is radiology, practices in Baltimore County. Thanks very much, Dr. Moss.
Okay.
Madam Speaker. Guest
Gentleman
announcement.
from Guest announcements, yes.
Yes. Permission to use delegates' names.
Permission granted.
Thank you. Wandering around the hotels in Annapolis last night, I ran into a group of students from Amherst College who have chosen to spend their spring break going to various government locations instead of going to Cabo for their spring break. And they actually, you might imagine that I was willing to talk to them for a while about government. Delegate Forbes also hung out with them for a while, and I know that Delegate Rosenberg has been part of getting them here. They're up in the rear gallery right now, and they are... This group of kids gives me a lot of hope for the future. They were intelligent, and they listened, and then they offered really good opinions, too, so thank you all very much.
Okay, thank you. Let me do, this is still March and still Women's History Month, and will the good delegate from Washington County address us, please?
Thank you, Madam Speaker. Colleagues, it's my honor to share with you a brief history of trailblazing Maryland woman, Rose Zetzer. Rose was the first woman to gain admission to the Maryland Bar and was the founder of Maryland's first all-female law firm. Her decision to become an attorney came after discussion in school about whether women should have the right to work. In 1918, 16-year-old Rose Zetzer was a high school student discussing basic human rights for women. Right then and there, she said, "I'm going to be a lawyer." And Rose not only became a lawyer, but in the process, she opened the profession for all women. Zetzer's first client paid her in candy. and her second in pantyhose due to reluctance to pay women. She was first attempted to join the bar in 1927 and was repeatedly rejected due to her sex. She was finally admitted in 1946, becoming the bar's first female member 21 years after she'd begun practicing law. Throughout her career, Rose lobbied in Annapolis for women's rights, including equal rights amendments and women's rights to serve on juries. While the 19th Amendment provided women the right to vote, it did not guarantee the rights of other citizenship, like jury service. Jury duty largely fell under state legislation, and many states did not consider women eligible for it. Jury service was not considered a suitable job for women to do to improper topics, and one might hear in court, and even a lack of women's restrooms in the courthouse. Zetzer and other activists dismissed such excuses and rallied and continuously. Because of their work, in the Maryland General Assembly passed partial women's jury service bill in 1947. Rose was inducted into the Baltimore City Hall of Fame in 1990. Please join me in celebrating Rose Zetzer.
Gentleman from Prince George's.
Thank you, Madam Speaker. Yesterday we had opportunity to welcome a lot of my fraternity brothers here, and I appreciate everyone for showing them a good time and then stopping by the office and getting some food if you got a chance to. But today I have a few more brothers here, and they're from the Chi Delta chapter of Omega Psi Phi. They are now celebrating their 50th anniversary. This is the chapter from the University of Maryland College Park campus, and they were established in 1973. So please give these brothers a warm welcome and let them know that we appreciate all of the things that they're doing and congratulate them on 50 years of service.
Gentleman from Frederick.
Thank you, Madam Speaker. St. Patrick's Day moment, Madam Speaker.
Go ahead.
Thank you. Happy St. Patrick's Day, everyone. The pins that many of you are wearing today came to us from the Senate of the Republic of Ireland, courtesy of Senator Mark Daly. I'd also like to take a moment to remind everyone that the Irish American Heritage Celebration will take place 13 days from now, Thursday night, March 30th, at the Annapolis Waterfront Hotel. We will be honoring the Irish American Legislator of the Year, the Chairwoman of Rules, and the benefit is the Special Olympics of Maryland. You can buy your tickets from me, the fair-haired lass from Anne Arundel County, or and we'll have electronic payment information to you first of next week. Thank you, Madam Speaker.
Thank you. Any other person or guest? Young lady from Anne Arundel.
Thank you, Madam Speaker. I just wanted to make a Lost and Found Caucus announcement. These wonderful glasses were left on my desk. Perhaps someone thought they were mine, but they are here. I will leave them here a little bit longer, and then I am going to turn them into Lost and Found. So if you're looking for your glasses. Oh, yeah, and also the back of a, this literally is the Lost and Found Caucus. The back of your pen, we have that here too. Thank you.
So if you lose it, give it to Anne Arundel. Okay. Gentle lady from Anne Arundel.
Thank you, Madam Speaker. Permission to use the delegate's name.
Permission granted.
Thank you. Well, today is not just St. Patrick's Day, but it's a very important day for the Anne Arundel County delegation because we want to honor and celebrate our favorite delegate from South County, because he's our only delegate from South County, Delegate Seth Howard. Happy birthday.
Any other announcements? Are you standing for something? Carol? Oh, when you stand up, I'm going to call you. Okay. Okay. Today is Friday. Protocol chair. Thank
Protocol
the pages.
chairs. Okay, you sunshines. Come on down. Come on down in the front, baby. Y'all have been fantastic this week. You've been rolling through this General Assembly. I want y'all to, haven't they been fantastic? Every time y'all needed some water, every time y'all need everything, our sunshine's been right there. And I want to thank you all. It's been a fantastic week. We're going to make sure everybody understands who you are again. And I'm going to put my glasses on so I can see on this paper. Okay, here we go. You ready? Okay, Kelly Bokum from Washington County District 2B, North Hagerstown High School. Mara Derwick, Baltimore County District 7A, Eastern Technical High School. Yoni Kidoff, Baltimore County District 11B, Bethfield Community High School. Molly Martin, Hartford County District 34A, Harvard D. Grace High School. Comfort Indy. Okay, I'm going to get this right because it's Prince George's County District 23 Bowie High School. Norma Romo Myers, Montgomery County District 20, Montgomery Blair High School. Finian York, Baltimore County District 7A, Perry Hall High School. Okay, I tried to get all of you wonderful people, and thank you again. My sunshines, I think you're probably going to be with us the second half. So, oh yes, you see them say, oh yes, they're going to take care of y'all the second half. Oh y'all, so thank you very much. Have a seat, you wonderful. One more announcement, madam.
Go ahead.
I'm going to make it short and sweet, okay? I think people really didn't understand what protocol means. And I want y'all to know, no, I'm serious. I want y'all to know it ain't all about the party, okay? It's about birthdays, and I send everybody a birthday card. It's about flowers. It's about being sick. Protocol does a lot more than just collecting for this Sanitary, even though I'm going to have the best of the best. But I want y'all to know that I'm only down to 16 wonderful people that has not seen the protocol chair. But guess what? I'm coming to see you personally. Okay, so thank y'all very much for helping me. I appreciate everybody. And thank you, Madam Speaker, for letting me make this nice, understanding announcement. Thank you.
You're quite welcome. Any other announcements? Okay. Quorum call before adjournment.
Madam Speaker.
Has everyone recorded their presence? Clerk will take the call. There being 134 members present, the House is still in session, recognizing the majority leader.
Thank you, Madam Speaker. Folks, listen up. Our Speaker likes to start on time. Yes. With that said, I move that the House stands adjourned until Friday, March 17th at 3:30 p.m., Legislative Day, March 10th.